For pronouncement of judgment, item 24.
If your lordship may permit, I want to make a request, your lordship.
Yeah.
The matter is very urgent. There is the eviction process from the,
After pronouncement of judgment.
Petition dismissed.
Oblige your lordship. Oblige your lordship.
may I please, your lordship?
Yeah.
The matter regarding the eviction of the catering vendors from the Lumding railway station by 15th August 2024, your lordship. Yesterday, a petition has been heard, no protection has been given, only notices has been issued, your lordship. Against that, your lordship, the filing process is under proceeding, your lordship. Your lordship may hear tomorrow matter, your lordship.
From which railway station?
Lumding railway station. My lord.
What is it?
There are 188 members, your lordship. Deep blue, guys.
May I please, lordship? This item may be come up on Friday, my lord. For
Friday.
application for slight modification.
For listing a matter. For listing,
For listing a matter,
what's the urgency?
orders, my lord. This is modification, last occasion, my lord, 6 August, your lordship was pleased to pass in judgment. Slight modification is required, that's why I filed an application. Already I have filed the application, so let me come up on Friday in the urgent matter.
That bank matter,
My lord?
bank matter.
Yes, my lord.
So that we have already pronounced that judgment.
Judgment, a slight modification is required, that's why, my lord. I will place the matter before you.
Friday.
Meet please before your lordship. Lordship, I beg to mention the listing of our read petition lordship on Monday, lordship.
Like-
Obliged, lordship.
Lordship, in item number 9, we have filed an additional affidavit, Lordship.
Item
Yesterday,
number?
9, Lordship. That may kindly be called for.
Call for it.
Yes.
Obliged.
Made please, your lordship. Lordship, in item number 12, the AG Mallard filed affidavit in opposition today itself, Mallard. So I may be allowed 2 weeks time, Mallard, to file a reply, Mallard.
Hearing matter.
Yes, Mallard.
Yes.
Much obliged.
I'm for the respondent, Lordship. I'm for.
Please, your lordship.
May it please your lordship, yesterday we filed the additional affidavit in connected matter, item number 3, lordship. That may be called for lordship today.
Item number 3,
3,
you have filed additional affidavit.
lordship.
Okay, call.
Much.
May it please your lordship, with the consent of the other side, I am praying for an adjournment in respect of item number 7 of the hearing list, lordship.
Why?
Lordship, Mr. Pathak has some personal difficulty today.
Yeah.
My senior, Mr. Pathak, has some personal difficulty today, lordship.
May I please your lordship, I'm for item 6.
Yeah.
Yes,
You are not
kindly
for the
adjourn,
opponent. Okay, adjourn. Adjourn.
adjourn this
Okay.
matter for 4 weeks' time as my
Which
seniors.
Which matter?
Item 6, as my senior's mother is in hospital. And also for the tribal affairs, they have already filed an affidavit and we are yet to
Adjourn.
peruse the same
Adjourn.
for 4 weeks' time.
Adjourn, please. Yeah. Request आपकी लिख लिया.
Your lordship, I beg to mention item number 18. This matter is fixed for hearing. Kindly adjourn for the day.
18,
18,
1-8.
1-8.
Adjourn.
Daily list, item number 1 for admission.
My apologies, my lord. We have already initiated the process towards compliance, my lord. There was an order of honorable single judge, wherein the promotion order was set aside and it was that.
When you are going to pass the,
My lord, we need some time. Yesterday, PCCR has written to the government for instruction, my lord. We'll be passing the order, my lord, very soon, my lord.
for instructions or for,
Because it was at the behest of the government cancellations were done. So he's just informing the government, my lord. Very soon, my lord.
after a week?
Let it be 2 weeks, ma'am.
Is the PCC present through VC?
Yes, my lord. With the PCCR establishment, additional PCCR. My lord, what has happened actually, it is to be blamed, I am to be blamed, my lord. They sought for a legal opinion from me. I thought, my lord, since the writ appeal is pending, there is no stay. So, my lord, I thought that let us wait for the outcome of the writ appeal. But definitely, my lord, the order had two components, my lord. One was to give grant promotion, and if they want, they can go for notice. They had only initiated the notice without giving promotion, which we are initiating now, my lord, very soon, my lord.
Okay.
2 weeks time, my lord.
Pursuant to the direction given by this court. The principal conservator of forest administration Assam is present to video conferencing. The net concern.
PN Goswami.
T.N. Goswami has assured this court that the order passed by this court on 1/2/2024. In this petition number 5299/2022 shall be complied with positively within a period of 2 weeks. In view of the submission of Mr. Goswami, this matter up to 2 weeks.
Obliged, my lord.
Thank you, my lord.
Personal appearance will be dispensed, my lord, for the time being. The personal appearance will be
Personal appearance of principal conservator of forest is dispensed with for the time being.
deeply awaited.
Item number 2.
Lordship, in item number 2, Lordship, we have filed our affidavit in opposition, Lordship, that is not in record, Lordship. We pray for another date, your Lordship.
Affidavit in opposition,
Lordship, filed by,
when you have filed.
we have filed it yesterday, your Lordship, yesterday morning.
In fact, Lordship, this matter was fixed for final disposal on 30th, 30. But somehow it has come today on 13th, maybe. So let it come on 30th for final disposal, Lordship. If required, we will file response to the affidavit also.
List this matter on 30th of August 2024 for final hearing.
Deeply obliged, Lordship.
Item 3 to 5.
Item number, Lordship, in item number 3 to 5, Lordship, we had called for our additional affidavit, your Lordship.
We filed a detailed affidavit, Lordship, in this case.
Consolidated.
Consolidated affidavit covering all the aspects, Lordship. So may I please, the Lordship, maybe please to fix this matter for final disposal, subject to Lordship's convenience.
Lordship, we have called for the affidavit, that may come on record, Lordship, and take up the matter for some time, your Lordship.
That's, you are in receipt of that consolidated affidavit.
Lordship, we have received the affidavit in opposition.
It's a consolidated affidavit has been filed in both the cases.
Yes.
We have
Now-
received.
Now you are in requirement of filing any rejoinder or something.
Lordship, we have already filed, Lordship, and we have called for
Just
the
let them.
Lordship.
Yes.
You have filed your made the submission. Yes.
Rejoinder, my lord, my learned president, I think that will work, his rejoinder. That rejoinder will work.
Okay.
Let it come, no?
Because,
After some time, my lord, it come, my lord, because it's,
ultimately, it's the validity of the ordinance is under challenge.
yes.
August 20 the next session.
Huh?
Next assembly session, August 20.
Yeah. The ordinance is still continuing to hold the field.
The assembly is sitting on 22nd. So if Lordship is pleased to take up for final hearing, Lordship, then it has to be before 31st. Otherwise, this petition will become infructuous.
They can very well amend that petition.
Yes.
In that case.
My lord, it's a purely a legal issue here. That's your lordship is aware of it. Take a legal issue on 2 points. One point is whether it is a fraud on constitution or what was the emergency situation under the provision of 213. That's the whole. It is not fraud on constitution. What was the emergency situation that triggered them to file the ordinance? That's the issue before this court. Whether it is amount to judicial review. That's the whole. My lord, because
The emergency situation, what do you mean by emergency situation? But the state feels that this ordinance is required, they have.
No, my lord, emergency situation on the ground, which they have taken on this ground, what I understand from their affidavit they have filed, is they say there are 2 acts. The one is Child Marriage Act, which doesn't permit under the 1935 Act for a compulsory. So that has triggered for number of child marriage has taken place. So they want to restrict it And there are two acts. One is POSCO Act of 2012. Another is Child Provision Act of 2006. So these two acts, which is directly in conflict with the 1935 Act.
One provision.
One provision of 1935. That's the whole case, my lord. And my lord, your lordship will just recollect 2006 Act, 2012 POSCO Act, and this is 1935 Act. What was the emergency situation of the state government to bring this ordinance? Because they could have brought earlier itself.
After deliberation in the house.
Yes.
Hearing them out, so hearing.
In those fresh petitions, the same issue is involved.
I'm sorry, my lord.
There are some fresh petitions in the.
I don't know, my lord.
this
See, only
supplementary dispute.
Mr. Chaudhary and I know that only.
Yes, my lord, there are three items I have, my lord. 20, 21, 22.
Yes,
All similar, my lord.
Identical issue, Lord.
so
This affidavit will give them a copy also.
But I have not received.
supply them a copy of this affidavit.
My lord, if it is not infringement to your lordship, subject to my learned friend, can be taken up on like Friday, it can be taken up this matter.
Friday,
If it is possible, if it is possible.
Friday is not
I
possible.
know. The lordship is burdened with number of cases.
Pursuant to the direction given by this
But
court.
I am ready, my lord, so
A
far as the case.
consolidated reply is filed on behalf of the state in one of the petition, which
Two.
in main petition number,
In Lordship, read petition number 2596/2024.
2596 of 2024. It is submitted by Mr. D. Sekel and additional advocate general that, sorry, advocate general that the reply filed, the consolidated reply filed on behalf of the state will cover all will cover all the issues raised in the connected petition. Stop, the consent for the petitioners are also in agreement that the consolidated reply filed on behalf of the state in writ petition number 2596 of 2024 covers all the issues raised in the connected writ petition. To stop, Mr. So-and-so has submitted that they have already filed a counter to the consolidated reply. However, the same is not available on record. The registry is directed to take the same along with the writ petition number 2596. The state is also directed to supply the copy of the consolidated reply to the counsel for the petitioners in the counsel for the petitioners appearing in the respect connected writ petitions. Having gone through the pleadings, we deem it appropriate to admit this, admit these writ petitions. No need to issue notice to the respondents as parties are already represented to their respective advocates. This matter for hearing on 20th of August 2024.
Deeply obliged.
It over, 3, 4, 5.
We'll give them back.
20th of August.
20th hearing day.
If,
Yes,
uh,
20.
suppose, my lord, your law, please allow me to do virtually if I am not there also on 20.
That is,
That's only,
you make a request, we'll consider.
if I am deeply obliged.
Obliged, Lordship.
Supplementary list item 19.
Yes.
Lordship, the impugn order, your lordship will find it starts from page 454. My lord, at para 32 of the impugn order, the honorable single judge has recorded categorical finding that there was gross violation of principle of natural justice in the entire proceeding. But at para 36, my lord, the honorable single judge has come to a conclusion that since the petitioners has already suffered the penalty, so meaning there is no requirement of interference. And in the operative portion, para 37, honorable single judge has interfered with serial number 4 and 5 of the impugn order. We were never agreed by that serial number 4 and 5. We were basically agreed by serial number 1, by which we were expelled and our registrations were cancelled.
But now, what is that expel period is already over.
But even then, it's over if your lordship tomorrow decides that the expulsion was wrong. My lord, in that even our job will be saved, my lord. That is the thing.
What about your, another prayer?
Regarding, my lord,
You have 100%
my lord,
weightage.
I'm explaining that, my
Please,
lord.
sir.
I'm explaining that, my lord. My lord, the weightage are, before the start of the semester, the weightage are earmarked. Now, the learned honorable single judge has found fault with the petition, appellants on the ground that we did not appear in the mid-semester examination.
This,
Now, lordship will kindly appreciate one thing, honorable judge, on single judge failed to appreciate that during that period, from January to, my lord, April, we were placed under academic suspension.
academic suspension, then during that suspension, you approach them to allow them to appear in the final examination.
My lord,
Who prevented them? Who prevented these petitioners to make a request for appearance in the
My
midterm
lord,
examination?
my lord, we repeatedly sent mails to the concerned authorities of the IIT praying for allowing us to come to the campus. Lordship will kindly appreciate the manner in which the proceedings were delayed. My lord, they, on 5/1/2024, they convened an SDC meeting wherein, my lord, we disclosed all the facts known to us regarding that night, my lord.
regarding that night, it is a case that where you remain absent without informing them on that night, this is an admitted fact.
Lordships,
Then what remains?
Milord, there was no intention to stay back at night, Milord. Lordship,
You could have informed them in the night itself. To
Lordship
the
will,
authorities that since this is the emergency and we are staying back here.
Milord, the emergency occurred in the morning 7:30 hours.
Sir, in fact, your defense is that after consuming whatever the
Yes, Milord.
alcohol and
Yes.
all,
One of the,
petitioner number 2
yes,
was unstable.
Yes.
And therefore you decided to stay in the hotel itself.
Milord,
Why
it
you
was.
have not informed them?
Milord, it was, I understand, Milord, Lordship is correct, but it was a decision, cumulative decision they can at that point of time that instead of returning, Milord, I appreciate.
That may be that
But-
decision is correct at that point of time. Decision may be
Instead of-
correct at that time. But who prevented you to inform the authorities?
Milord, when,
Would have saved
in the morning hours, Milord, 7:30, our friend, that late Aishwarya, she suffered breathing problem. We took her to GMCH, Milord, and thereafter she passed away. Milord, there was no decision, previous decision that we will stay back. We were supposed to return back.
Certainly, sir.
But it's true. Lordship is
Was a
absolutely,
spontaneous decision, no problem.
yes, Lordship is
Why you have
absolutely,
not informed them that we are, today we are not coming. We are staying. in the
Lordship is
hotel for
absolutely
count of
correct.
days or whatever the reason. may be.
Lordship is absolutely correct, Milord. They should have informed. But for that purpose, this penalty of expulsion, Milord, in my humble prayer, Milord, Lordship will kindly appreciate. We'll lose our entire career, Milord. We'll lose our entire career.
Leonard Single Judge has already granted you the liberty to appear in the examination and also in the
Milord, in that,
selection, whatever it. you call
that
it.
was the, Milord, Milord, direction in the penalty order itself. But if we, Milord, impart in the next semester, Milord, the job offer which we have got, that all the job offers will be, Milord, cancelled, Milord. We lose our jobs, Milord.
Certainly, at that time.
We lose our jobs. And Lordship will,
Again appear in the campus examination and you get it.
Lordship will kindly appreciate.
The rate of nature of memoranda shall not be issued directing the respondents to give 100% wages in the.
Milord, this
examination.
weightage I can explain, Milord. Milord, before the start of the semester, the weightage are given, Milord. If I take your Lordships to one paper, Milord, Lordship will kindly consider.
Mr.
Lordship-
Das, weightage are not given. What is given, what is depicted is the manner in which the weightage will be given. How can you get weightage for something before you even undertake that exercise?
Milord, mid-semester examination, not a non-appearance, Milord, they cannot take benefit of their own wrong. Milord, I was all, Milord, Milord, what I am trying to submit, Milord, the petitioners were all along wanted to come back because Lordship will kindly appreciate their students, they were forced to go back. Milord, so far as they were all along praying.
You are asking for credit for an examination which is already gone by.
No,
And
what
you
I am
know-
asking is that whatever assessment, whatever exam, Milord, I have submitted 6 assignments out of 6, 2 quizzes that I have attended out of 4, and I have appeared in the end semester examination. Milord, if your Lordships kindly come to 2 and 3 of the writ appeal, Milord, the weightages were already, Milord, declared prior to the start of the semester. So even going by the assessment made on the basis of 6 assignments, 2 quizzes, and the end semester, Milord, marks, I passed through, Milord. That is my prayer, Milord. Milord, my prayer is that, Milord, do the assessment not on the basis of mid-semester examination. You do the assessment, whatever, Milord, I have participated, you do the assessment on that basis.
Is it permitted? Is it permitted?
No, my lord.
Then Is it permitted
Milord,
under the?
what
rules
I'm-
or whatever it
I
may be,
understand,
that
Milord.
only evaluation would be done
I-
on the
I-
basis of end semester
Milord.
examination and not on the basis of.
Milord, I
mid-semester
understand your
examination.
lordship's query, Milord. My contention is that, Milord, I have challenged the penalty order, Milord. Milord, if I succeed in my challenge to the penalty order, Milord, the consequential decision pursuant to that interference or my success would have to be that
Where is the penalty order?
penalty order, your lordship will find
Number one.
page 150.
Expulsion.
Apart from that, the grounds considered, but I'm sorry. Page 150.
Take number. We got. The petitioner has enrolled for the semester from July 2024.
Milord, as of now, I don't have that instruction, Milord, because they are pressurizing, yes, true. They are writing repeated mails that you enroll. Milord, that instruction I'll have to take, Milord. But so far as,
You get that instruction, subject to what my lord, the honorable chief justice said.
yes,
We can allow you to enroll without prejudice to your rights and contention in this writ appeal. Otherwise, you take a risk. If you don't succeed, then that goes, this goes, both goes.
Lordship.
You are back by quite a few years.
I understand, Milord. Milord.
Take that
In fact,
risk.
Milord, my
You
advice.
want to take that instruction, you have 15 minutes to do that.
Yes. My lord will also, my lord, lordship has seen the impugn order. Lordship will also see the show cause notice, the manner in which it was issued. In the show cause notice itself, my lord, they have said
Don't go
that,
by technicalities.
no, my
What
lord,
the facts are.
what I am saying,
Those facts are either you say that you haven't you people have not stayed in that hotel on that day without the permission of the this university or the IIT concerned. Show us.
my lord, it was an instantaneous decision. There was no,
Thus, you don't have a good case on merit. Be reasonable. Get your instructions.
I'll just get the instructions, my lord. Lordship will take up after some time.
Tomorrow?
Lord, after some time, my lord, I'll just have a,
Okay, at 2.
yes.
After, yeah.
My lord, I might able to assist this honorable court. I was being told telephonically, my lord, that there is some undertakings that required to be given every semester, my lord. Every semester, my lord, and student is required to give an undertaking and forms have to be filled up. I am being told over the phone that these petitioners have filled up the form and undertakings have been, they have given the undertakings already. I had asked already to them to send me those copies of the undertaking, the forms which they have filled up already.
Undertaking saying what?
That they wanted to take admission in the July 2024 semester.
All right, let him obtain
My lord,
instruction.
my lord.
That will be without prejudice to their rights and contentions. We'll hear this and decide on merit.
Yes,
At
ma'am.
11:30.
Yes, ma'am.
You also can get some.
My lord, I'll get it, yes. Deep to-
Item 23,
DPO.
Lordship, I am appearing for the Treasury Officer, Lordship. I have given two instructions, Lordship. Here, the PPO was sent, Lordship. Lordship may just go through the letter, Lordship. Oh, Lordship, I got the communication today itself, Lordship. I apologize. I did the. Here, basically, the PPO which was sent by the AG, my lords, that had already expired because the PPO has a expiry limit of 1 year, my lords. So the Treasury Officer had written back to the AG on 25th of June, saying that they just need to revalidate the PPO and send it back to the Treasury Officer. Upon receipt of the PPO, revalidated PPO, my lords, within 1 week, the bills, they can make the bills and make the required payment, my lords. The revalidated PPO has not been received by the Treasury Officer. I have received this instruction.
Who will issue this?
The Accountant General, Lordship.
Accountant General.
Yes, Lordship.
By what time?
Lordship,
Next week, Lordship, I will obtain.
once we receive the revalidated PPO, Lordship, within 1 week, we can pass the bills. That is the instruction which I have received. And one little aspect is that the petitioner needs to visit the Treasury Office and confirm the account details and the few documentation, Lordship. That is after we receive the revalidated PPO. Lordship.
Once I am called, my lord, I am ready to visit.
Lordship, I'll take the contact number that we will manage, Lordship. That won't be, once we get the, only the.
Yeah, Learned Counsel appearing for the Treasury has submitted that they have already requested the
Principal.
Accountant General Office to submit the revised PPO.
Lordship, revalidated PPO.
Revalidated PPO. So that the pensionary benefit will be dispersed to the appellant. Full stop. It is the Learned Counsel appearing for the Accountant General has submitted that the process, as per his instructions, the process will be completed within a period of process of issuance of revalidated PPO would be completed within a period of 1 week.
Next week, Lordship, I will.
Within a period of 1 week. Full stop. It is also informed that for the purpose of issuance of revalidated PPO, the appellant is required to
Visit the Treasury Office.
No, not for the public. For the
Bills.
disbursement of pension.
It is also informed that before disbursement of the pension, the appellant has to complete some formality
By personally appearing before the clerk.
some formality by personally appearing before the Treasury Officer. Learned Counsel for the appellant has submitted that the appellant would appear before the Treasury Officer as and when informed. I should stop. Let this matter after 2 weeks.
In the meantime, the process.
In the meantime, it is expected that the process would be completed. The whole process would be completed.
Indemnity bond, madam, regarding
Whatever it may be, what formalities she is required to do, she'll do. He agrees to that.
Oblige, my lord.
For hearing, item 8 and 9.
Before my learned friends, third lordship, on the last occasion, there was a issue about paragraph 19, where the deponent stated that.
Paragraph
15. I'll just 1 second.
15, paragraph 15.
Paragraph 18
18 of what?
of the affidavit file
By the respondent number.
by the respondent,
Number 6.
yes. The respondent number 6.
Now.
Hmm.
15.
Paragraph 15, page 12. They are trying to convert the whole case on this paragraph, paragraph 15 of the affidavit filed by respondent number 6.
Respondent number
And respondent number 6 is the gratuity commissioner. Paragraph 15, Lord.
Not 15.
It is the affidavit filed on
Well
Lordship,
covered.
can you take up item number 9? Item number 9.
Item 9.
Krishna beer.
This is item number 2066. 2066.
2066 read petition.
Yes, 2066.
Yes.
Lordship. Paragraph 15, page 12.
Page
12.
155. 155. Running page.
Page 85, my lord. The internal page 12.
Mr. Saikia, respond number 6 has filed additional affidavit yesterday.
Yes, Lordship.
Are you referring to that?
No, I'm referring to the original because on the basis of this paragraph, they wanted to convert the whole case on the basis of this paragraph. The internal page is 12,
85.
page 85,
Running.
the running page. Main case to please put over. Main case to-
2066.
Prayer.
Circular of 2018 project. Sector 1.
Yes.
That with regard to the statements made in paragraph 19 of the writ petition, the deponent states that 60% of the total wages of the past 12 preceding months will form the contribution to the fund for payment of gratuity to the employees who have already rendered service prior to the commencement of the Assam Gratuity Act 1992.
Yes.
So according to them, all these things will come only prior to the commencement of a Gratuity Act of 1992. That was sometime in the year 2001 or 2. But that is not the correct position. There's an inadvertent mistake committed by the deponent here. We have to look at the act as well as the scheme. What is the language there? So on the basis of some statements wrongly incorporated in the affidavit, will not change the color of the whole scheme or the act, Lordship. So a administrative officer cannot overrule or override the scheme which is already in place. There is no ambiguity on the language, no ambiguity on the act also. So this we have in our subsequent affidavit, which we have filed yesterday, we have admitted that we have made a inadvertent mistake in this case, Lordship.
This is another affidavit is on behalf of respondent number 6.
Same incumbent, Lordship. Yesterday we filed it.
Yesterday.
Yes, Lordship. We have admitted our mistake.
In which para?
Paragraph number 7, my lord.
7.
7.
I represented the state of Assam, Lordship, here. My learned senior friend and thus appears on, but paragraph 7.
Yes.
That it is 272 running page, that the deponent most respectfully states that the statements made in paragraph 15 of the earlier affidavit was an inadvertent mistake on our part, and the deponent further stated although the Assam Gratuity Act came into force on 1/1/2002, but the gratuity scheme could be implemented only after publication of the notification of 29/1/2018 by the additional chief secretary Assam. So that admission is there, Lordship, that we have committed the mistake. It may not be very clearly in the subsequent language of the same paragraph, but what I am emphasizing is that the mistake has been admitted.
No, but then that affidavit has to be withdrawn.
Whether that is permissible or not, Lordship. Once an affidavit is filed, whether it can be withdrawn.
you can seek the permission of the court.
Then that we have to do, Lordship. But in any case, ultimately, Lordship will have to look into the scheme, the act, as well as the affidavit, which will ultimately prevail because Lord, they have challenged the whole provisions of the act as well as the scheme and the notification issued thereunder. মই ইহঁতকো appeal, মই তোমালোককো appeal, represent কৰি আছো। তুমি কৈ দিয়া, they would like to file an application to it, ক'ব লাগিব।
Yes, Mr. Datta,
My lord,
what do you have to say?
yes, the act is absolutely clear.
No, not on the act. They are saying the statements earlier made in para 15 of the first affidavit was an inadvertent mistake. So the correct position is not what was stated there, but what is stated today in the additional affidavit filed
That you
yesterday.
can accept, my lord. That you can mark.
That you can accept.
Yes, lord. That may be, but the affidavits of what the earlier file where the mistake has been tracked up, that has to be either to be not placed or by the order of this honorable court.
So you will appropriate application for
Lordship, my learned senior friend and thus appears for that incumbent.
so today you have filed on behalf of this respondent number 6 another affidavit.
I have not, they have filed, Lordship. I am harping on
The
that.
state has filed.
No, respondent number 6, gratuity commissioner.
Commission that we have filed my lord yesterday, my lord.
So then you move an appropriate application for this withdrawal of the earlier affidavit. Otherwise, if both the affidavits are on record, then which affidavit is to be relied upon?
This additional affidavit that will do, my lord, that will suffice, my lord. This earlier affidavit filed by us, my lord, that we may be allowed to withdraw that affidavit, my lord.
We'll file a proper application for you.
The appropriate application has to be filed, my lord. With all respect.
Consider oral request.
Lordship has clear. But our difficulties is, my lord, that we have filed our reply in respect of the earlier affidavit. So we have to, again, we have to file and reply.
Opportunity to file counter.
Lord, Lord.
During the course of hearing, during the course of hearing on last occasion, the counsel for the petitioner has submitted that the respondent number 6 that in the affidavit in opposition filed on behalf of the respondent number 6, the case of the petitioners is admitted by the admitted as per the para number 15 of said affidavit. Full stop. Faced with the situation, Mr. Sekia, Advocate General, placed some time to complete his instructions, and the matter is listed for further hearing today. Full stop. Today, an additional affidavit is filed on behalf of the respondent number 6.
No, my lord, it was filed yesterday.
Yes,
my lord.
yesterday an additional affidavit was filed on behalf of the respondent number 6, mentioning that the government's mail in the para number 15 of the earlier affidavit filed on 3rd of July 2021 was an inadvertent mistake. And in the fresh additional affidavit, the position of law as it exists today is mentioned. Stop. The net counsel appearing for the respondent number 6 has made an oral request to allow the respondent number 6 to withdraw the affidavit in opposition filed on 3rd of July 2021. So stop. The net counsel for the petitioner, there is no objection if the respondent number 6 is allowed to withdraw the affidavit filed, affidavit in opposition filed on behalf of affidavit on 3rd of July 2013th or 13th of
13/7.
in place of 13th of July 2021. So in view of the above, we allow the withdrawal of the affidavit in opposition filed on behalf of the respondent number 6 on 13th of July 2021. The additional affidavit 2021. Stop, learned consent of the petitioner praise some time to file counter to the additional affidavit filed on behalf of the respondent number 6 on 12th of August 2024. Time period for is granted. This matter for
On 23rd of September, if it is permitted.
23rd of September.
Lord.
For
Before that, we have filed our account. For 24th, my lord. Hearing date.
listed for 23rd of September 2024.
My lord.
In the hour, the same may not be treated as part of.
Deeply obliged.
However, the case may not be as part of.
Grateful.
Item 19.
Next, 10%.
I've taken the instructions, my lord. They have submitted the undertaking.
They have already submitted their.
Yes, as said by.
So they are willing to get themselves.
Yes, my lord.
registered.
The order your lordship is proposing to be passed without prejudice, my lord. That will suffice the purpose. Only prayer before your lordship is that, my lord. Lordship will hear this matter at an early date, my lord, if not inconvenient to your lordship, my lord.
Okay. Mr. Das on instructions has submitted that the petitioners have already applied for
Registration
applied for registration
for the July 2024 semester.
for July 2024 semester. For subsequent semester commencing from July 2024. The petitioners have already applied for registration in the subsequent semester commencing from July 2024. Full stop. In view of the above, full stop. However, paragraph. However, Mr. Das has submitted that he is challenging that in the writ petition, the petitioners have challenged the punishment order in toto and not in part. Full stop. He has submitted that the learned single judge has interfered with the impugned order partially and only the disciplinary action contemplated at serial number 4 and 5 are set aside, whereas essentially the petitioners are aggrieved by the disciplinary action contemplated at serial number 1, 1, 2, 3 or 1?
One, my lord, basically
Or
one.
1. Full stop. Issue notice, learned counsel appearing for the
IIT, my lord, for respond number 3 to 7.
1 and 2. Mr. So-and-so has put in appearance on behalf of the respondent number 2. Mr. So-and-so, 1 and 2. Mr. So-and-so put in appearance on behalf of the respondent number 3 to 7. Service is therefore complete. The counsel for the respondents may file their response to the to this writ appeal by the next date of hearing. It is made clear that the registration of the petitioners in the semester commencing from July 2024 will not prejudice their rights and contentions raised in this writ appeal. Stop. Does this matter for
In this month itself,
not this
my lord, kindly, because otherwise,
11th of September?
Oblige, my lord.
can,
This
can
was
it be in can it be in first week of, not, if not convenient?
The previous campus selection is gone. If you labor more on that, it will cause problem for your clients. Target something which is feasible, Mr. Das. You are a counsel. You don't behave like the clients.
No, your lordship is correct, my lord, but that
We'll consider on next day. 11th of September. Yes.
Item 10.
Lordship, could it be taken a little bit later? My assisting counsel is on legs in court number 4. I am prepared with the case, but I may need some support. Lot of paperwork earlier. But issue is very simple. Lordship, it is against the challenge of a so-cause notice against trade reversal. So on that ground, 7, 8 issues were framed and 3 issues went against us. 4 issues came in our favor. But whether at the stage of issuance of so-cause notice, whether the learned single judge was correct in delve into such depth studies and analysis. All the grounds which they have taken in the writ proceedings, they could have replied in their so-cause notice. The law is well settled. When a so-cause notice is issued, all the grounds are available to them to urge before the appropriate concerned competent authority. And the law also, I'd like to place from the Supreme Court also, whether the penalty part can be incorporated in the so-cause notice or not. That went against us. That is the core issue. Whether in the so-cause notice, the penalty provision is also to be incorporated or not. The law is well settled that it has to be mentioned. Even a whisper has to be given. So after some time, Lord.
Item 11.
Lordship, this matter, there is a challenge to the rules. And on the last occasion, Lordship was pleased to direct for my appearance. Today, they have informed me that I have to appear in this case. So I need some time to go through the papers and address this honorable court.
Okay, Mr. D. Senthia. Noted Advocate General. Raise some time to prepare the matter. Is this matter 2 weeks?
my lord,
Lord.
2 weeks.
There are 8 hearing matters in my name today, Lordship. I prepared 5.
You are supposed to prepare all.
Lordship, actually, I'm a little bit unwell for last 3 days. That's why I would have prepared all 8 cases.
Item 13.
But 3 fully prepared cases got adjourned today from the other side. Deeply of that, Lordship.
Lordship, kindly matter me password for timing, Lordship. My senior is on legs, Lordship. After some time.
Time.
Item 14.
This is a appeal preferred by the state of Assam I am also appearing for the Karbi Anglong Autonomous Council in this case, Lordship. The matter relates to an order issued relating to attachment of the principal of Difu Government College. In Assam, there are 3 or 4 government colleges. One government college is in Difu. So he was appointed sometime in 2011. And immediately after his appointment, Lordship, series of troubles cropped into that institution. And it went to the stage of complete standstill at some point of time because of various unrest caused due to the involvement of the principal as well as of the other factors or stakeholders in the institution. So the impugned transfer order page 91 in the writ appeal 336. May I read it, Lordship? In the interest of public service. So I'm sorry. Must be very difficult for the আমার একটু difficult single the Then the Supreme Court order to say. Supreme Court of Bangalore. You know that? Voice
After passing of this stay order by this court on 12/10/2023, whether we have joined as OSD in the directorate of
That is why when the matter came up before division bench, without going into, now I have joined. They joined in persons to the division bench order.
You have
Yes,
joined?
yes, we have joined. Because that was the issue, my lord. The matter when it came before division bench, without going to merit of the case, that was the first question your lordship was asking. That was, why you didn't join? Because there was no interim order at that relevant time. There was thereafter no interim order. You have been.
Single judge has granted you 14 days time
Yes.
to join as a
Yes,
OSD, and you have not complied with that. That was their case.
Yes. No, in pursuant to order passed by this court, same by this, then we joined. Pursuant to order passed by this court. We are still there as OSD. But basically, the merit of the case by the division bench was not taken into account only on the ground that first question that came, why you didn't join? That's why in pursuance to that order, my lord, we have joined.
Yes.
He did not join in terms of the learned single judge order in the writ. That is number one. After 1.5 years, he did not join. Then finally, the order was passed by the learned single judge in his favor. We came before this honorable court. This honorable court was pleased to stay it. Then he went to the Supreme Court. In Supreme Court, he faced a dismissal. Then only he joined. Now he has joined.
Come on, merits.
Yes, now. Page 91. He availed all legal remedies, but he did not get it. That's why he has compelled. But he violated the learned single judge's order. The arrogance is there. 24th September 2021. In the interest of public service and administrative exigency, Government of Assam in Higher Education Department is pleased to attach the service of Dr. Nirav Kumar Sharma, Principal, Difu Government College as officer on special duty, OSD, in the Directorate of Higher Education, Assam, Kahilipara, and Abdul Motin, Associate Professor, Senior Most Faculty Member in the Department of Commerce, is allowed to hold the current charges of Principal of Difu Government College until further orders with immediate effect. Dr. Nirav Kumar Sharma shall draw his pay and allowances, etc. from the Difu Government College as usual. And Lordship will also mark at the copy, serial number 7. Dr. Nirav Kumar Sharma, Principal, Difu Government College, Difu. He is requested to take over charges OSD of Director of Higher Education, Assam, Kahilipara, and hand over charge to senior most faculty member of the Difu Government College immediately. So from this order, we cannot discern anything that this is a transfer order. His post will remain vacant. The substantive post is lying vacant. Somebody will just discharge the duties, but his salary, etc., he will be getting from Difu, and nobody is replacing him as a permanent principal of Difu Government College. This gentleman, Lordship, this Abdul Motin, he retired 6 months ago. Then another person was allowed to function as principal there, but no regular headmaster principal has been appointed there. The stand of the state of Assam before the learned single judge, page 94. 2 paragraphs, small paragraph. Okay. Paragraph 6. The deponent begs to state that by notification dated 24/9/2021 is not an order of transfer. It is a temporary arrangement for attachment which is required for some specific academic reason. There is no regular replacement in his place. Nobody replaced him, and he is not replacing anybody. The deponent further begs to state that the question of cadre does not arise here. Petitioner retain his substantive post, that is the principal of, and the petitioner does not lose any benefit of substantive post. Next paragraph, Lordship. Attachment of the services of the petitioner as OSD in the Director of Higher Education, Assam has necessitated on administrative exigencies to utilize his service and expertise. It is an in-home arrangement for special purpose so that the academic works relating to new education policy and college-related works in the Director of Higher Education is properly monitored. So the petitioner is given the special duty to look after special works. So this is our stand, because there are some administrative reasons why we are picking him up from Difu College, that the Karbi Anglong affidavit will clearly place it before this honor.
But before the division bench at the time of stay, your stand was altogether different.
Lordship.
Before the division bench,
Lordship.
when this stay order was passed on 12th of October 2019.
We file another affidavit. That also I have come.
Your stand was altogether different.
No, we have, because we have relied upon the Karbi Anglong Autonomous Council. They have elaborated the whole story. I have that next affidavit. I'll come now. We have filed an affidavit here. one single division bench order to get a discuss of. Okay, it's a division bench order. Higher education permanent forever, not translate.
What was the Madras case which delved into this, whether ex-cadet post? I think it was.
Lordship,
IS
what that law will not apply here because his post is still there. He is holding that post still. He is working in the directorate as a OSD. The situation certain situations we cannot visualize in the normal. We have whether we would like to compromise with the academic atmosphere of DIFU College, or we have some alternative administrative to exercise action which can prevent the institution from degradation. We have to look from greater public interest. That is why that before the division bench, we filed an additional affidavit on 19th of September 2023. The division bench granted the stay on 12th of October, 1 month later. In that affidavit, Lordship will find the affidavit filed by Karbi Anglong Autonomous Council was annexed. Let me place that, Lordship, because the infighting and the unruly activities that is going on involving extremist persons, involving police, all other persons who are not supposed to be there in the institutions are part of the activities of the institution. And who are the sufferers? The students. So we have to preserve the academic interest and academic atmosphere of the institution so that the ultimate stakeholders, the students, should not suffer. Because of his inaction, he failed.
Mr. Saik, just a minute. See, nobody is questioning the reason why you did it.
Lordship.
That is the prerogative of the administration. We are not questioning it. What would be an issue to be decided here is, assuming that everything that you say is right, the procedure adopted, whether it is a recourse permissible under the rules or not. If it is not permissible, then regardless of whatever be the reason, it has to be interdicted. If it is permissible, then even if there is no valid, unless it is totally arbitrary, the courts will not interfere. The question here, as we could understand from their case, is that this was a single cadre post of principal. He was selected by the APSC process and appointed. After that, he has been now shifted to an OSD is obviously an ex-cadre post.
Ex-cadre.
It's an ex-cadre.
Temporary.
Temporary. Now, if there is an allegation against the gentleman initiating disciplinary action or any penalty, that is another matter. But now is a situation where he is the principal, but he will not be the principal. That's the situation now. So the only issue is whether under the service jurisprudence, this is a permissible recourse.
Absolutely.
So
now,
we are asking you,
if he is a principal and if he is getting all the benefits as a principal, what is his problem? Whether his service conditions is been adversely affected or not. He is getting all the benefits, he is getting all the promotions. all his service conditions are well taken care of.
Yeah, that will be effective.
Nothing is adverse against him. And in 2020, the national education policy has come. He has his expertise, so we are using his expertise.
That is why I was asking, there is a judgment of Madras High Court long back on this point. There the Supreme Court has held that unless there is a violation of terms and conditions of service, this kind of shifting is permissible. Do you have the judgment?
Lordship, let me, one day time maybe I will find it out and place it.
I'm not remembering the name.
But I have some orders because attachment. What I am trying to emphasize is that it is attachment, not transfer. We are not transferring him.
Yes, the core issue will be whether there is any violation.
Now,
of
Lordship will kindly see from 2020 and once he is out of that institution, there is not a single incident. The school is progressing, the college. Prior to that, from 2012 till 2021, every third day there is an incident. Either the fourth grade employee is being beaten by him, or there are some police coming in trying to arrest him, or he is filing an FIR against the students or his colleagues. Alpha is involved in his activities. Alpha is protecting him. He invited Alpha. These are all parts of record.
These are serious misconduct.
Very serious
You
misconduct.
should have taken action instead of.
Once we tried to, in 2014, attempt was taken. Then somehow it did not fructify into final dismissal. It is in his interest, Lordship. If the government starts taking all these actions, it will go detrimental to him. He is a competent person, no doubt about that. So we are utilizing his service. He has the audacity to violate the Honorable Court's order. I will not go and join there. For 1.5 years, he was sitting at home in spite of their clear-cut order. So that is the arrogancy of a person. And he wants justice from this same Honorable Court. After the divisions bench also, he went to Supreme Court and he found dismissal. So at the last moment, he withdrawn it. That order also I have. Let me place that order also for Lordship's consideration. He was compelled to withdraw the petition by the Honorable Supreme Court. So now whether a private interest will be more important or a public interest will be more important. Sometimes we have to have some free play from the rigors of the law. Thereafter only he came and joined. We do not want a battleground to develop in the Difu Government College. Last 4 years, not a single incident. No unruly behavior. Getting all the accreditations from the competent authorities by the college. If the college is functioning well without a principal also, it is good if it is progressing. Time lole আপোনালোকক গালি কৰিব দিব। আৰু চেভিত টাইম ল'ম বুলি চেভিৰ মাউণ্টটো পিছফালে আহি বহি আছে। বহি হৈছে ফটো। দেখাতে Memory by itu proper আমরা তখন করা তখন বেশি ভালো
Second, what is your specific strength? Is it a transfer or simply an attachment?
It's simply attachment.
Attachment, then your affidavit says something else.
The subsequent parts, the law relating to, because it is in response,
But it is not a transfer. How
it
you are
is
making such
because it was in
suggestions?
response to their writ petitions, those paragraphs were written.
Sir, it also not says in response to the petition. You simply
bec-
said, and then after again.
Because
in
they
this
have
para
cited
number
some
eight-
laws.
para number eight,
I fully
nine,
appreciate what Lordship is saying. Absolutely
number eight,
correct.
9 and 10, everything you
But
replied that transfer is permissible,
ap- ap-
transfer is permissible.
I fully agree because they have converted the attachment into a transfer. So counter to transfer,
Your
this
stand
was
must be
written. It
specific.
should not
is
have been
a
it.
transfer matter. Why
Kill-
you are justifying this by
Now, Lordship, it is very
indicating
clear
so
from
much
the
weightage
language
on
of the impugned order. The language of the impugned order and the two paragraphs which I have placed. That is the actual stand of the government at that point of time. The subsequent are in response to their pleadings. No, we have to teach ourselves, Lordship, absolutely, that certain things we should not write in our affidavits. That Gilapukhuri case also taught us, and this also is teaching us. So, Lordship, we have filed an additional affidavit before this honorable court in the division bench on 1970. If Lordship is pleased to take up that affidavit. The language of the impugned order, the attachment order, Lordship, is very clear. When a particular person is transferred to another, then in his place, another person has to be brought in. That is not the case here.
Yes.
So Lordship would kindly take my affidavit, additional affidavit of 1909 before this honorable court.
Just a minute, just a minute.
Yes.
If Lordship is pleased to, because in the additional affidavit, those grounds were taken in the interim order of this division bench. If Lordship is pleased to come to page 112. Paragraph 6.
Yes.
According to them, one ground is that the state government does not have the power being a transferred subject to the 6th schedule area of Karbi Anglong. Here we have stated the Department of College Education General is an entrusted and delegated subject of the council. All the officers and staff of the department entrusted and delegated to the council are under the administrative control of the council. Difu Government College is also imparting education of class 11 and 12, which is a part of secondary education. So secondary education still lies with the state of Assam, which the Karbi Anglong also won't dispute. The Difu Government College is the only government college of the district and is a premier institution of the district. Ever since the petitioner had joined as principal of Difu Government College pursuant to the order of 13/1/2012, there has been series of allegations against him by the faculty members and the students of the college, as well as the public of Difu town regarding his arrogance and high-handed behavior. Council has always tried its best to resolve the matter amicably to bring about a normalcy in the campus, keeping in mind the interest of the students and academic atmosphere of the college. The petitioner was also called by the Authority of Education Department of the council, who advised him to treat his colleagues and even students with respect. He apologized and even stated, "Perhaps I have made a mistake by behaving in this manner." The situation became worse when on 16/7/2013, he allegedly assaulted one of his own students just because the student dared to ask him why classes were not held regularly. After due inquiry, a joint secretary of Karbi Anglong Autonomous Council, the authority placed him under suspension and initiated departmental proceedings against him. The petitioner did not reply to the so-called notices. The Honorable High Court, by order dated 11/12/2013, suspended the order of suspension, and the petitioner was allowed to continue as principal of Difu Government College. In compliance of the order passed by the Honorable High Court, the authority passed the order dated 7/3/2014 for his reinstatement. When he was told that he could have approached the council to present his point of view and the matter could have been resolved without jeopardizing the academic atmosphere of the college, he replied, "I have decided not to set foot in the council. My only fault is that I am not a Kirby."
Mr. Saike, just 1 minute.
Lordship.
Mr. Saika, there is one query to both of you. This DIFU college is under the administrative control of the Karbi Anglong Autonomous Council. Education is a transferred subject, right?
But one part of that institution also lies with the secondary education, higher education part,
One part means,
higher education part. Up to 11, 12, they control. Then beyond that graduation part, the secondary education,
so
higher education comes.
the post against which the private respondent was appointed, principal,
Yes, Lordship.
that post is under the administrative control of the council or of the state of Assam?
Huh? State of Assam.
That is state of Assam. That
Yes. And he has been selected by Assam Public Service Commission at the request of the Higher Education Department of Assam.
Not at the request of the council.
Not at the request of.
I'll show one judgment of the Supreme Court, which my learned friend, I'll answer to your lordship's query because it's a legal issue. Whether in respect of, that's our whole case before learned Singh.
no, but if you was in the, if that post is controlled administratively by the state of Assam,
Yes,
then Mr. Das, subject to what you may like to say, we don't need to go very deep into it.
yes.
Putting him in an ex-cater post is permissible under the law unless you can show that this has resulted into violation of conditions of his service,
Yes. I'll
not
show
the
that.
pleasure of his service,
No, no, the condition
not
of
the
service.
pleasure of his office.
Co-
Conditions of service, not the
Condition of
pleasure.
service. Condition of service of conditions of which are the post. I will kindly see that, man. In my learned friend, it is
Here,
complete.
that's the point here. What else is there?
My lord, the point is, point.
There is
was-
no violation of condition of service. This
My
order.
lord, your
My
lordship-
submission is very clear to that point.
Your lordship has said that point, but that point was never raised because whole case is about a transfer. I'll project. That was the case. Before the.
No, it's not a case of, please, it's not a case of transfer because he is still drawing his salary against the post of principal of DIFU college. Is
Yes,
that correct?
Lordship. Yes.
So the transfer, please do not label.
No, I will just address to that point, my lord. I address to that point. That was the case which was projected. He may draw his salary from his substantive post, as a principal there itself. But that Supreme Court has depicted because you have to compare both these posts by drawing the salary from the substantive post. What is the effect of it? I'll show the judgment of the Supreme Court. I'll show the judgment, my lord. It has to be equivalent, same post. It has to be an equivalent post. I'll just put, I'll answer to your first query.
No, that is if both posts are cadre posts.
No, I'll tell you, this is why I'm saying, my lord. Under the rules, if you see the rules, my lord, which are the cadre and post? Let's see the rules. I'll show the rules, my lord. Yes.
That's one.
Move to export. Education. My lord, I'll just place it one point. Before your lordship goes to the rules, that is Assam education, that's what your lordship's query was there. Whether if you're done under the rules, absolutely there is no problem. Assam Education Service Rules, 1982.
Assam,
Assam Education Service Rules, 1982.
1982.
My lord, your lordship will kindly excuse me for one. I'm sorry for bothering your lordship. Can I just draw the attention of the judgment where it is reflected, then I'll go through this judgment. My lord, I'm sorry for that, my lord. I'm troubling your lordship. I'm sorry for that. No, I will just show that. I'll show that. Kindly see the impugnable orders. Page. Yes. My lord will kindly see the judgment at page 20. I'll show the rules, my lord. It will be easier if we connect with the judgment. Kindly see page 20 of the judgment. And the rules thereafter I'll show it.
Page 20
Of the judgment, of the appeal, read appeal.
Nanit single judge.
Yes.
Yes.
Para 6. My contention, my lord, thereafter finding. So and so appearing on behalf of, your lordship got it, my lord. Submitted that the attachment order issued by notification of 24/9 is the nature of deputation without taking the consent of the petitioner. Therefore, the same cannot withstand the test of law. He submit that the post of OSD is not a cadre post under the Assam Education Service Rule 1982. Further, as no prior consent was obtained from the petitioner before attaching as an OSD from his substantive cadre post or the principal of Diffu Government College to a non-existing post, notification dated 24/9/2021 requires interference. It is also submit requirement and condition of service of teaching staff of the government degree colleges are regulated by the rules of 1982. It is the pre-amended rule of 1982. The post of principal government colleges are to be filled by way of promotion from a common gradation list. However, after the amendment of the rule of 1982, with effect from 15/9/2009, the recruitment to the post of principal shall have to be made by direct recruitment only. As a result of this said amendment, the post of principal of Diffu Government College has become an independent cadre. Accordingly, in terms of the amended rules of 1982, the Assam Public Service Commission published an advertisement in the year 2011 for filling up the post of principal in different government colleges. At the relevant point of time, as the petitioner was serving as associate professor in chemistry at Diffu Government College, he offered his candidature for the post of principal at Diffu Government College and duly participated in the recruitment process. And thereafter, he was selected, appointed to the post of principal of Diffu Government College by notification dated 13/01/2012. As such, the post of principal Diffu Government College is a single cadre post which is not transferable. However, by notification dated 24/9/2021, petitioner was attached as OSD in the Directorate of Higher Education. It is also submitted. Attachment of the petitioner OSD in the Directorate of Higher Education Assam was at the behest of the Karbi Anglong Autonomous District Council on extraneous consideration by influencing government to issue the improved notification dated 24/9/2024-21. Therefore, the notification dated can be considered as punitive in nature and also not sustainable. In this context, we show judgment of this court as well as the apex court saying that if it is an OSD, is like a deputation, you have to take consent of the particular person. That what we have shown. Now kindly see the finding on this point. Finding at para 12. Para 12 is the finding. Now, my lord, I will just, his submission at page 22, my learned friend advocate general submission is at page 8 statement submission. Para 8, sorry, para 8. Page 22. So and so has been issued in the interest of service and in administrative exit attesting the service as OSD in the Directorate of Higher Education Assam. Same is not an order of transfer, and it is only a temporary arrangement for attachment which is required for a specific academic region, and there is no regular replacement in its place. It is an in-home arrangement for special purposes so that academic work relating to education, new education policy, and colleges related works and Directorate of Higher Education is properly monitored. He also submitted a petition as failed to re-accelerate the college of so and so, which deprived the college from receiving grants from so and so quality. It is further submitted. Diffu Government College, the only government college in the district, as a premier institution. However, since the petitioner joined a principal, there has been series of allegations made against him by the faculty member and the student of college, as well as the public of Diffu town regarding arrogance and high-handed behavior. The academic atmosphere was highly affected, and the teaching and non-teaching staff of Diffu Government College also submitted a memorandum to remove the petitioner from the post. Tenure of the petitioner principal of Diffu Government has been marked by problem with agitation by students and several complaints of the faculty member of the college as well as from public for his behavior to the students and faculty member of the college, and to maintain cordial academic atmosphere in the college. Notification dated was issued attaching him as OSD with responsibility of monitoring the new education policy, college related work. He further submits that the attachment order does not amount to transfer a petitioner from his substantive post, and therefore there is no question of notifying contributing the provision of rule of 1982. Submit a petitioner yet to join his place of. Now the contention which my learned friend has advanced before the court was that the atmosphere of the court, kindly see. So that's the reason why we have placed him as an OSD. Not for the purpose of public interest. There is a punitive in nature, my lord. That's what you are saying. See, 12 was the finding. Rule 3 of Rule 1982 prescribe the class and cadre of Class 1 and Class 2 employee of the Assam Education Service. A perusal of the same would indicate post of OSD in the Directorate of Higher Education does not form a part of class and cadre of Class 1 employees of the rules of 1982, and therefore same will have to consider as an ex-cadre post. A perusal of the notification dated 24/9/2021 clearly indicates petitioner is attached an officer on special duty in the Directorate of Higher Education, and one Abdul Mutin associate senior most faculty member in the Department of Commerce in the Diffu Government College is allowed to hold the charge principal of Diffu Government College, Diffu. The vital issue in the present writ petition is whether petitioner could have been transferred to the post of OSD in the Director of Higher Education. The rule of 1982 do not admittedly cover the post of OSD in the Directorate of Higher Education, Assam. Therefore, the post of OSD will have to be considered as an ex-cadre post. An employee cannot be sent without his or her consent to an ex-cadre post. Attaching an employee to an ex-cadre post would basically mean that he is on deputation, and therefore he is sent on deputation. Consent of the employee is required to be obtained.
That's, with all respect, that's not the correct exposition of law. Putting in an ex-cadre post does not amount to deputation.
But that's I will show a judgment of this court. I'll show the judgment which has been decided. Your lordship may differ. That's what I place it before the court. Anyone, my lord, the whole case projected by not getting interim order by this court was his transfer. I'll show it. There's the affidavit which has been filed. And they have mentioned, my lord, all different stance has been taken. Once, when arguing before the learned single judge, while I was pressing for an interim order, the ground which was taken was a transfer. Not OSD. We a transfer, we have got right to transfer. See the grounds. Well, all different stands has been taken. Kindly see their affidavit. Kindly see the affidavit which has been filed before this court. Kindly see that, my lord. See the affidavit, my lord. In the writ appeal. I'll just draw your lordship and at 126. Kindly see at 126. Then at 126. See 126 at paragraph 7. See 126 at paragraph 7.
126.
126.
This affidavit filed in this writ appeal?
Yes, yes. 126. This separate, my lord, this, which was filed, I think, later. Later on, it was filed.
Yes.
126. Lordship
Yes.
got it? 126?
Yes.
126 is a part of an order passed by the court earlier.
Yes, yes. Yes, that's why I'm saying, my lord. Kindly see. Argument at para 7. Para 7. The learned advocate general, well, learned standing counsel and respondent have submitted. There exists sufficient material to justify the transfer of the petitioner, which would be placed before the court if a reasonable opportunity is granted to the respondent authorities to respond. It is also submit. Transfer of the petitioner has been necessitated basically on two grounds. Firstly, the new education policy of government has been launched in the state in the year 2020 in the line of national education policy, and there was a pressing need to have an academician in team. And secondly, continuance of the petitioner principle of default government college has vitiated the academic atmosphere in the state college, and therefore interested it was deemed appropriate making an alternative arrangement as done now. Academic atmosphere of the college can be resorted. It is submitted. No service condition has been changed to determine of the interest of petitioner. Continue to draw his salary in the substantive post. Pronouncing communication dated position can be restored. He would not suffer any prejudice except. So this is a stand they have taken. And there are several judgments which have been cited before this court. My lord, what was I'll show, my lord. Kindly see the affidavit. Again in the affidavit in the appeal, page 90, which my learned friend was reading, the state affidavit at page 93. 93. See at paragraph 95 at paragraph 8. See at paragraph 8, my lord. 95.
Just one minute, do you have the copy of his appointment as principal of Diffu College? Is it
Yes,
there on
yes.
record?
Yes, yes. I think we have annexed
It's in the repetition.
in the writ petition, my lord.
Page 77. Page 77.
Single cutter. Single cutter post है तो election answer business. 25 में 50 में करेंगे. The principal is a single cadre post.
Yes, single cadre. My lord, kindly see at page 95. For a moment, 95, my lord.
Is the order of appointment there, principal?
I'll show it. Only for a moment, my 95. I'll show the order of the. See 95 para 8. Para 8. The deponent begs to say service of the petitioner is governed by the Assam Education Service Rule 1982. Rule 26 of the Assam Education Service Rule deals with transfer. 26 of is set out below the ready reference. Every member shall be liable to transfer anytime. Now, this transfer, which my learned friend was citing by paragraph, what has happened, my lord? This initially, it was transferable. Inter colleges, this is like Cotton College, now it is university. Now Diffu College, now Haflong College, the Kokrajhar College, these are government college. There could have been transferred. Now, this rule was amended. This rule in 1982, it was amended. After the amendment, what they decided that no, will not transfer. Lecturer, principal will remain the same colleges because someone is taking the advantage. Suppose someone wants to in the government Cotton College, he doesn't want to go to that Diffu College because interior place. Government decided to amend it. This amendment was put to challenge before this court. This amendment, this rule was put to challenge. Then how it is you have done it? Ultimately, the court said no. We will not touch that because there are a lot of reasons was given. So that is why transfer is not permissible. Neither the principal nor the lecturer transfer is not permissible. So inter-college, in government college, transfer is not permissible. So that is why while arguing the matter, while all this was taken, my lord, we argued this matter. And your lordship now want to show, you want to see my appointment, see at page 77. See page 77. He says 77. On being recommended by APSC so and so is appointed principal of so and so. Initially, my lord, the principal post was a promotional post. Initially. But what they have done, 2009 it was amended. It is a single cadre post, my lord. It is a single cadre post. Initially, my yes.
Yes.
So, my lord, they could not do it by way of transfer because they have amended. It is a single cadre post. It is not an encadre. It being an ex-cadre. So what they have done, they have directly put me in OSD attachment. Being a single cadre post, my lord, and transfer not permissible because of the amendment. They could have transferred. Well, they have got right to transfer if it was permissible under the rule. They can't do it. 26, my lord, is not in relation to the principal or the lecturer, in relation to some others. My lord. So their whole case was that. But when I argue the transfer is not permissible because in view of the judgment of this court amendment. So, and number two is a single cadre post your lordship want to see it. So that's my whole case. And my lord, if something is there, draw a department proceeding and means I'll reply it. There is absolutely no problem. Because your lordship from the very beginning, your lordship was saying, show me the rules. If it is permissible, of course. I'll concede, my lord. It is not that I'll concede if it is permissible under rule. Now, the point which your lordship, they said, no, he is getting the salary from his substantive particular post. Now that
Is there any change in the condition of his service?
Yes,
What is
that
it?
was a principle, and this is my
That's the change in the pleasure of service.
No, let's see. Now, like,
Please don't mix the two.
No,
Pleasure is one thing, condition is
no,
another thing.
I will show it. Condition is different. Yes, I will show it. Equivalency of post. That is very important. I'll just show before your lordship. That's the whole point. I knew your lordship may ask, so I was prepared with the judgment. I don't know whether your lordship will accept that I have to show it. Para? My lord will kindly see paragraph 8. If your lordship kindly see para 2 for a moment, factual part with para 2, the issue involved, lordship got it? Para 2, the issue involved in the appeal is as to the power of vice chancellor of a university under section 1014 of the act to transfer any teacher of any department or college maintained by the university from the post of principal of a constituent college to the post of reader of another constituent college maintained by. High Court, while allowing the writ petition held, although the two posts of principal and reader are carried on the same scale of pay, it could not be said post of reader is an equivalent post as the post of principal in the legal sense. In coming to that conclusion, it placed the emphasis on the difference in status and the position of the principal apart from the privilege that he enjoys, which according to High Court give me an edge over the teaching post in an institution. Now kindly see that's the issue. See paragraph 8, how it has been dealt by the kindly. My lord, sorry. My lord, bang on this point, it is a case of principal to reader. Principal reader, my principal to OSD. Bang on this point, the Honorable Apex Court at paragraph 8 kindly.
Sir, here in that case, principal is also a cadre post and reader was also a cadre post.
Which one? I'm sorry.
In this case.
Yes, yes, sir, right, correct,
Both
correct.
have the cadre post.
No, you're also right, absolutely correct.
Here ex-cadre post.
No, that's right. But my lord, still what is done, my lord, kindly see para 8. Your lordship is right, absolutely correct. See para 8, the prerequisite of power of vice chancellor under section 1014 of the Act to transfer any teacher, because here you cannot transfer under the rules. Here you can transfer. Any teacher occupying a post in any department or college maintained by university to an equivalent post is another department or college maintained by it in that must broadly bear the same characteristics. The mere circumstance that two posts are carried on the same scale of pay is not enough. This is because in the original text of amended Act, the word used in 1014 as well as expression other equivalent posts as defined in 2 courts are so and so. The learned counsel respondent is therefore right in contending that equivalence of a pay scale is not only the factor in judging whether the post of principal and that of reader are equivalent posts. We are inclined to agree with him. The real criterion to adopt is whether they could be regarded as equal status and responsibility. That's important. Equal status and responsibility. Now you go further, my lord. Now you, if your lordship kindly see next in that view, I'll just keep this in that view. Lordship got it? In that view, there cannot be no doubt that two posts of principal and reader cannot be regarded as of equal status and responsibility. The true criterion for equivalence is the status and the nature, responsibility of duty attached to the two posts. Although the two posts of principal and reader are carried on the same scale of pay, the post of principal undoubtedly has higher duties and responsibilities. So how can, my lord, if it is also drawing the salary, it doesn't mean that it has got the same responsibility as a principal with that of OSD. Lordship is right. It is a case where because there is a provision for transfer here. So under teacher, principal and reader, both transfer. Now you may get the scale is same, but what is about the responsibility, the post, whether it's same status? So my humble submission before your lordship is that what is not permissible under the rule. Number one, this OSD, which they have brought, and they have brought me, my lord, it's an ex-cadre post. Under the rules, it's not permissible. So in the guise, on the other hand, you said it's a transfer. Transfer is not permissible under the rules. Not two judgment, quick judgments I will show, my lord. On the point of OSD, my lord. I'll show two judgments, quick judgments. Only your lordship can note, I'll give the judgment. What was the judgment of this court by a division bench challenging the rule? It is transfer is not permissible. That I'll just, your lordship can note down 2014. I have given that. Transfer is not permissible. 2014 3 GLT page 564, paragraph 26. Para 26, my lord. Lordship got it, man? Yes. Para 26. In the case at hand, the amendment as already indicated above has introduced a scheme of formation of independent cadre for each of the 4 government degree colleges. Now, Cotton College is not no more under the government. It is now Cotton University, man. Breaking the common cadre of the said 4 degree colleges into 4 independent cadres cannot be said to be bad in law. petitioner cannot claim any vested right to be transferred to Cotton College when the Constitution makes it obligatory for the government to treat its citizens on equal footing and provide every citizen with good quality of education. If that be the government's aim and also the duty, there is no reason for lecturer who has already been appointed to a particular college to claim he has inherent right to be transferred to a college located at a more developed place. If this argument is accepted, the poorly developed areas would never be provided good education and would be made to suffer from lack of good quality education. So in the present, government decided to give. So this rule, my lord, which they have amended, that was upheld. That was upheld, the transfer not possible in respect of those colleges. This is one. Number two, my lord, ex-cadre. Next 2004, supplementary 8 to 7. 8 to 7. Para 38. Para 38. Lordship, got it, madam? Para 38. Let me now come to the question as to whether the writ petitioner could have been transferred to the post of OSD. While dealing with this aspect of the matter, it is of utmost importance to note the recruitment rule do not admittedly cover the post of OSD. Thus, the post of OSD aforementioned is an ex-cadre post. To an ex-cadre post, an employee cannot be sent without his or her consent. Transfer of a person to an ex-cadre post basically can be only on deputation. And if he is sent on deputation, his consent is required to be obtained. In the case at hand, no consent whatsoever the writ petition was admittedly obtained and no such consent exists on record. Thus, the impugn order transferring the writ petition to an ex-cadre post, such an OSD so and so is wholly illegal and cannot be sustained in law. Reference made by so and so in Punjab, so and so is not wholly misplaced in as much as Apex Court has laid down to the effect government servant cannot against his wishes be transferred a post outside the cadre of his service. My lord, here it was permissible transfer. Here in our case not permissible. But whether if it is ex-cadre post, then you have to take consent. Another judgment I'll show it, my lord. At 2008, 2 GLT page 718. Para 8, my lord. 2008 to GLT 718, paragraph 8.
2008
to GLT.
This is 2008 for GLT 30.
Sorry. 2008 for GLT.
GLT or
GLR page 30.
Para
30. Para 8 to how to? Para 8. Para 8. Lordship, what is para 8? For contra, the contents of the respondent is that transfer being within the power of government in terms of FR 1115. Petitioner cannot question the impugn order by which he was transferred in OSD, the Director of Higher Education. This submission is not acceptable for reasons discussed above. As the post of OSD is not a transferable post with the post held by the petitioner, save and except with the prior consent of petitioner, consent having not been obtained, transfer order cannot be sustained. Secondly, when qualified person is able, as is evident from the order, extra to hold the post of principal or college either on a charge basis, officiating basis, it is not understandable why a person not having the requisite qualification for appointment as principal college should be transferred and posted principal in charge of the college. Having considered the matter as discussed above, this court has no hesitation to hold the action of government in issuing the impugn order is arbitrary, violative of statutory provision, as such the same is liable to be questioned.
transfer.
No, these are all because that was permissible transfer because it doesn't permit because it was an ex-cadre post. It was not an encadre post. That's the principle.
The transfer is another thing, but they claim it's not a transfer, it's simply attachment because no other person is posted against you and that is not at all permissible.
No, that's why being a single cadre post principle, whether my lord under the law, whether it is permissible to bring me as an ex-cadre post. That's the issue, my lord. Whether it is permissible. Rule doesn't permit. It doesn't fall. That's the whole case. That's my submission for lordship. That's my submission for lordship.
If lordship permits, can I give my reply day after tomorrow, lordship?
He's not feeling well.
No, it's not that.
No,
I have to address on the ex-cadre and that part.
Yeah,
Yes,
that's the critical point here.
yes, lordship.
You have to show us that this ex-cadre shifting
Yes,
is
lordship.
permissible under the law.
If it's not included day after tomorrow, lordship, I'll address all these.
After tomorrow, we are not coming to court.
I'm sorry. 16th. On Friday, lordship. We have, that Madras judgment is with us now, lordship. We have already got it.
What is the citation? Can you please?
Citation. And we have a attachment, Punjab High Court's order, I have already placed.
Mr. Das, please.
Yes,
have a
I
look
look at. That's why I'm writing. Yes. What is
So the citation.
citation?
2007 Supreme Madras 2982.
Supreme Madras
2982.
Anniversary.
2984. 2007. If there is a judgment of the Supreme Court and it says the issue, then I have to accept.
Let us look at it.
No,
Let us
I
find
say,
This is a persuasive
I-
argument I will make.
I cannot, my lord.
No, it ultimately went to Supreme Court.
Yes,
Judgment I'm
that's
talking
what I
about
want
went
to show.
Supreme Court.
The Supreme Court key was that's important.
It was a case of an IAS officer who was shifted to an ex-cadre.
My lord, we look into it. The judgment, we look into it gone to Supreme Court, we'll search it also. Yes, I'm deeply aware.
Item 15 to 17.
Mr. Babujari, perhaps on the same issue, there is a division bench judgment which was delivered by Honorable Justice H.N. Sharma and give me judge, I don't remember, sitting in the Aizol bench.
idle bench.
I somehow remember because the same issue was raised by the Mizoram Employees Association. Notional benefit and pecuniary benefit.
Yes, yes.
Same, that court has delivered a judgment. Do you have it?
I will have to check it because I am fortified with one decision of this honorable court passed by learned single judge, which my lord is perimeter and which my lord is absolutely on the same reasoning, my lord, as has been propounded in my lord Amarnath Goel. Now that is the precise issue here, whether the state would be within its legislative competence to fix a cutoff date. Now, DS Nakara is a constitutional bench decision.
That DS Nakara has been considered in the division bench judgment.
Yes, now DS Nakara has also been considered in Amarnath Goel, which we are heavily relying upon here in my lord. The Amarnath Goel says, my lord, that if there is, my lord, financial constraints on the part of a state, then the state is within its legislative competence, or my lord, for that matter, my lord, it will be within the
for motion purpose will be affected. Challenge.
in the.
Do you have any idea of the judgment? That will go against him.
Yes, Lordship, that law has changed, Lordship. The Mizoram's judgment, Lordship.
What is that?
I'll place it, Lordship. In fact, I have already told him that although earlier judgments were in our favor, the recent judgment has gone against us.
That judgment is in your favor. Yes.
Harder.
No,
That-
Aizawl bench, Aizawl bench.
No, it's in Supreme Court of Mizoram. I'll place that, but that Aizawl I have no idea, but the judgments we relied upon, Amar Singh Goel's law, that has been reversed by the Supreme Court by a recent last year's judgment.
Okay.
When this review application was pending. But the other side have never, but I told my learned friend that
So now this has to be confirmed.
we have to
Single
confirm.
judge, single
Lordship.
judge judgment has to be confirmed.
Lordship,
Show that judgment reverse. The
Yes.
No.
I'll do that, Lord.
Today you can give it.
Let us examine on Friday, Lordship.
Generally saying what happened to you, you should have the.
We have brought that judgment also for this honorable court. We do not want to hide this judgment.
In fact, our prime contention, Your Lordship, would be differentiating the matter of state of Punjab versus Amarnath Goel on facts. What has
But
happened?
now he's saying that the Supreme
Yes.
Court has otherwise decided in your
In
favor.
fact, Your Lordship, what has happened, subject to what Your Lordship kindly says, that in the other matters, there was a cutoff date which was given, and the litigants before this Honorable Supreme Court were excluded from the cutoff date. Here, the petitioners before Your Lordship were not excluded from the cutoff date. We were included within the cutoff date, and thereafter a separate categorization was made, whereafter we were only given the notional benefits. The OAM had sought to take into account an effective date under which we would fall. We would fall under the effective date. We are not excluded. We are not excluded. We would fall under the cutoff date of 1/1/2006. However, from the period of 1/1/2006 to 31/3/2009, there was a further class which was created. We were sought to be given a selective benefit pursuant to the notification that we are challenging. And that is the prime basis on which we can differentiate on the basis of facts of all the Supreme Court judgments. That will be my final submission before this honorable court. That DS Nakara would be the one which will be applicable in terms of the idea and the aspect of what a homogeneous group would constitute. My contention here is not that I have retired or expired before 1/1/2006.
Can you give the citation, please?
The latest judgment which
Yes, Lord.
Learned Advocate General is
ইয়াত আছে uh, 2020 14 SCC 625. Itu judgment. Can you recent judgment holo?
This judgment covers the issue
Yes,
here.
yes, Lordship. All Manipur Pensioners Association versus State of Manipur. এইটুকু subsequent আবার বেলেগ হইছে নাকি?
Acha, Mr.
This
Corporator,
judgment held Amarnath Goel's law is bad.
Please check out on the Mizoram.
Yes, Lordship, we'll try to explore that also.
SLP.
Lordship. Most of the people of research করিবে না
Amarnath Goyal is a two judges.
Yes, Lord.
Yes, two judges. So coordinate bench has said the earlier judgment was bad.
Uh,
ये सकार है तो फाइल
It started from 1994, Lordship. Union of India versus PN Menon and Tamil Nadu State Electricity Board 1999. So 1994, 4 SCC page 68 and subsequently 1999, 3 SCC page 414. And if I'm not wrong, that 94 judgment overruled Nakara's case, Lordship.
Nakara is a constitution bench.
Yes, Nakara's case was distinguished by the 1994 judgment.
Nakara is a
One point, Lordship will here itself, it is in paragraph 14, 11, and 20. It would be a 19 distinguished. No, not full facility. It would be Nakara distinguished for a paragraph 14, 11, and 20. Itu আমার against itu আমার Goel. আমার Goel. আর এটা আমার বলবার
Friday, 16.
Friday, Lord.
Friday.
Passover meter 10.
My lord, I think it will take time. My lord, second half, I have some personal difficulty.
Which?
Item number 10
Item number 10.
in your lordship. It was clear call, my lord. Friday or any day.
Now it will go in September. September. Yes.
September this date. Deeply obliged, Lordship.
Pass over matter 13.
Single judge has passed this judgment method, assuming certain facts to be admitted by the respondents.
Who is appearing for the respondent?
I'm appearing on behalf of Mr. SP Royal.
You are ready?
My senior just coming, Your Lordship.
Okay. There are two. हो गया बाकी सर हो गई क्या
Item 13.
Yes. What are these two applications?
Well, one is under section 19 of the MSA Act. Agitating, they're praying therein that before passing the judgment or hearing the appeal, 75% amount is to be deposited. It is a mandatory provision under MSME Act.
But that is in respect of where to deposit that?
In the court, Lordship.
In the court, which provision says this? Which is that provision of the MSME Act?
MSME, section 19.
Section 90.
Yeah, there is also apex court decision, our own high court division with judgment is there. আমার রেগুলারই করা হবে
Do you have a copy of that?
Yes, sir. Lordship, I had flag number 9, Lord. Flag number 9 is our Supreme Court of India. Para 11 and 12. Paras 11 and 12.
Division nine.
Where is the provision that section 19?
Section 19. That speaks of the.
Just a minute, that's why only we are looking into it. Do you have copy of the act?
Yes, yes.
Please give us. So, क्या हुआ? Yes.
Yes.
It's speak about any order made by the council or by an institution.
By institution or any other lordship, the words are in the.
Or institution center providing alternate dispute resolution to which the reference made by the no application for setting aside any decree, award or other order made
Yes.
either by the council itself or by any institution or center providing alternate dispute resolution services. So how this
Section 7 of the interest on payment proceedings. Yeah. Order for government will find there. But here the statement is written, it's not free. इसके अंदर एक बोली इसके लिए very बहुत समय लगेगा। बड़े तो गए आप नहीं ये मतलब चाहिए हटने का भी करने का strictly speaking नहीं है 7 or 19 का नहीं है।
So your application is for that.
Yes, Lordship. Otherwise also, Lordship, if there is a simple money decree, if the appeal is prepared, generally, Lordship,
In that case, their argument would be that why you have approached directly to the High Court.
I
You
raised
could
this
have
question,
approached
but
You could have approached the council itself.
no, Lordship, because their submission of the appellant is this, Lordship, there is no privity of contract between the appellant and the respondent, private respondent, Lordship. That was the submission before the learned single judge.
That has been negated by the learned single judge.
Huh.
That has been negated by the learned single
Yes,
judge.
yes.
But in that case, after all, it's a contractual matter.
Contractual matter, that is correct,
And
Lordship.
strictly speaking, the court should not have exercised jurisdiction in Article 226.
Lordship should be pleased to consider that when the sole, that there is no, their sole submission before the learned single judge was, Lordship, and prior to that also before filing the petition, that you are a subcontractor and we are not responsible. If there is no privity of contract, Lordship, then the arbitration clause will not be applicable to me, because my case is based under section 70 of the Contract Act. So under the provisions of the section 70 of the Contract Act, if anybody executes a work but without any graduation, Lordship, then in that event, Lordship, when no contract, written contract or oral contract is required, the person who gets the benefit of the work bound to pay, Lordship. A series of judge, I have given the entire bundle of the judgment.
Start. Yes, Mr. Sekia.
So far as the miscellaneous application, Lordship has rightly pointed out, it is only against the council's order or any decree passed by the council. So therefore, it is not applicable. They have raised this question before the honorable single judge also, but that is not at all entertained. They have not preferred any appeal also. Now here, my lord, we are aggrieved, basically, honorable single judge has passed the judgment on the basis of certain facts, but as admitted by the respondent, which are in fact not, my lord. So far as completion of the work, that we did not agree. So far as amount is payable to him, he has completed his work. This part
are not admitted. In fact, the entire project work, only 1.98% of the work has been executed in total. And out of that, he was given a subcontract of 60 crores. Out of that, when the contract was terminated, at the time of termination payment, unpaid work is valued. So unpaid work that has been done by the writ petitioner, we have measured it and it has been found that 11 crores and odd rupees he has worked. But we never said that the work has been completed by the subcontractor as well, because his total work is 60 crores. It is only 11 crores and odd he has performed the work. Now, second is that, first of all, we don't have any PVT of contract with them. He is entitled to that 11 crores and odd. He is because he has worked for it, but not from us, but from the
Original contractor.
principal contractor, because we don't have a PVT of contract, and rather, my lord, the terms of the agreement as well as various documents to show that, my lord, it is specifically mentioned that you cannot assign it without the consent. And in fact, the approval letter also, we have clearly says that you cannot assign the contract to the subcontractor. He'll be performing as a subcontractor, not as an assigner to the principal contractor.
He has to perform as a?
As a subcontractor, but the entire liability, everything will be with the principal contractor. So if this assignment is been done, that has to be with the.
There is a approval, Ranjit Singhal observed that this NHIDCL has approved that subcontract.
Subcontract. They also clearly mentioned, my lord, you cannot assign it. Whether he does the work, my lord, rightly or wrongly, he will not be answerable to us. The principal contractor will be answerable to us. Whatever work he does, it will be submitted to the principal contractor, and we have the authority engineer, he'll verify, and then principal contractor will forward it to us. And then we'll pay the amount to the principal contractor, and thereafter, as per the terms of the agreement between the principal contractor and the subcontractor, he'll be entitled to that amount.
Yes.
Now, your lordship, if your lordship looks into the judgment at page 519. Lordship may come directly to my lord, page 531, paragraph 34. Paragraph 34, from the facts and circumstances which have been discussed above, the following position are also admitted by the parties. Emerges the contract agreement in question dated 1911-2014 permits subcontract. That is admitted, my lord. The subcontract to the petitioner was given after approval from the concerned respondent. That is admitted, my lord.
That is admitted.
Yes, approval was given to him.
And this contract agreement in question permits subcontracts, that is also admitted.
My lord.
This number 1 is admitted, number 2 is admitted.
Lordship, my lord.
Okay.
Various reports which are part of the record would demonstrate that the work which was entrusted to petitioner was completed in all respect. In fact, the fact also admitted by the learned counsel for the respondent. This is not admitted, madam. This is, I never submitted before the court that the work has entirely been completed, madam. Then, madam, there are various clauses in contract from which the petitioner appears to be assigned of the principal contractor. But here, you will find, madam, page 147.
First read this other points also.
Numerous communication includes communication dated 4/11/2016, 45 the stand of the petitioner. This is also not admitted, my lord.
There is a
The respondent number review. Respondent number 3 and 4 in the affidavit in opposition dated 26/2/2019 had made the following admission in paragraph 11 and 12, which are extracted herein below. that with regard to the statement made in paragraph 27 and 28 of the writ petition, the answering deponent bets to state that in consequence of to the termination of contract four-laning from Jorhat to Jhaji, section 9, NH 37, due to gross default on the part of the previous EPC contractor, Corson Cobium Construction SA, authority engineer determined the valuation of unpaid work completed, uncompleted, as per provision of clause 23.5, article 23 of the contract agreement. The gross valuation of the unpaid EPC work completed, uncompleted, determined by the authority engineer is rupees 12 crore 26 lakhs 35,331, out of which executed under scope of subcontract Messrs. Green Decker is rupees 11 crores 6 lakhs 85,770, and under scope of subcontract other subcontractor is 1,949,561. That with regard to the statement made in paragraph 29, the deponent begs to state that the work done by the Green Decker, which had been assessed and certified by the authority engineer, letter number so-and-so 38, 2018, has been accounted for in the termination payment of Messrs. Corson Cobium Construction SA. The only reason discernible for refusing payment is that the principal contractor CCCSA did not perform a portion of the work leading to termination of the contract at the risk and cost of the contractor. However, the gross valuation of the unpaid work was calculated to be rupees 12 crores 26 lakhs 35,331, which was executed, out of which the work done by the petitioner was of rupees 11 crores 6 lakhs 85,770. And the amount in question is admitted by the respondents. But the amount is that which is we have admitted that what work he has done, whether completed or uncompleted, that is valuing rupees 11 crores and all. Not that it is payable to him. Rather, in the previous statement, we have said this is accounted for termination payment of the principal contractor. Because the contract is between the present appellant and the Corson Cobium, the principal contractor. So termination payment will be made to the principal contractor. So this amount we have taken into consideration, and this has been added to the termination payment form under the Corson Cobium, the principal contractor. And thereafter, it has been found that after adjustment of there was 43 crores and odd were to be received, recovered from the principal contractor. So this has been adjusted, and thereafter something 11 crores and odd still remaining to be recovered from the principal contractor. And in fact, in the writ petition also, he never stated that he has completed the work and therefore the payment has to be made. What he says, the amount which to be paid to the principal contractor on account of the work executed by him should be retained by the present appellant and should be paid to him. But that has to be accounted for. This amount we have accounted for. It is not that he is not entitled to that, but this has been accounted to the principal contractor to whom we have to make the payment.
The Arbitration Act controversy. But you cannot be left with
What is this concept? This concept under the MSME Act is constituted by which section?
Section perhaps 20, my lord.
20.
20.
And what are the functions of the council?
My lord, 18, my lord, it gives some light, my lord. Section 18, notwithstanding anything contained in any other law for time being enforced, any party to a dispute may, with regard to any amount due under section 17, make a reference to the Micro and Small Enterprises Facilities Council. On receipt of a reference under subsection 1, the council shall either itself conduct conciliation in the matter or seek an assistance of any institution or center providing alternate dispute resolution service by making a reference to such an institution or center for conducting conciliation, and the provision of section 65 to 81 of the Arbitration Act and Conciliation Act 1996 shall apply to such a dispute as if conciliation was initiated under part 3 of that act. When the conciliation initiated under subsection 2 is not successful and the stands terminated without any settlement between the parties, the council shall either itself take up the dispute for arbitration or refer it to an institution or center providing alternate dispute resolution.
Now, Mr. Saikia and Mr. Roy, we want you both to consider this and respond. Please listen to. See, there are two verticals in this matter. One is the technical-legal argument, no privity of contract, etc. This is there. The other is you are an authority under Article 12, and you are aware that MSME enterprise was engaged in execution of a part of the work. Now, the learned single judge has issued a mandamus, which we are tentatively in agreement that with the kind of fact situation that probably was not correct. Because whether he is entitled to or not, merely because somebody has referred to 11 crores, 6 lakhs, that by itself may not be a ground to issue mandamus. It cannot assume the form of a money decree. There has to be adjudication on entitlements by interpreting the contract. That has not been done. So to that extent, we find that there is some force in what you are arguing. But at the same time, this writ petitioner has got certain protections, statutory protection under the Micro, Small and Medium Enterprise Development Act. This statute prescribes modes and manners of protecting the interest of the MSME enterprises, which includes first a mediation. If it fails, then refer the matter to arbitration. That would be a statutory arbitration, not an arbitration within the meaning of correct. So in essence, what we're saying that, of course, both of you can argue, that is another matter. But though tentatively we are in agreement with you that by a writ of mandamus, perhaps pay 11 crores or 12 crores, that perhaps may not be justified. But at the same time, since it is not between two private entities, one of the entity is a other authority under Article 12, and the principal contractor has left the country, is nowhere to be found. You were not in dark that this party was working. So taking these facts into consideration, when there is a statutory provision, he deserves an adjudication of his rights and his entitlement. That cannot be denied.
No, that cannot be.
That cannot be denied. And in view of this Act of 2006, the privity of contract is not an argument.
No.
That argument is totally negated.
No, that is.
Whether you had a privity of contract or not, you forget it. You knew he was working. So therefore, if he has a right, that has to be recognized. But it cannot be done by a writ of mandamus in a writ petition. It has to follow the statutory prescription.
Right.
Otherwise, Mr. Roy, you may go to this level, you'll again come back. Think about it. We can always pass an order, but we want both of you to apply your minds and think about it. This is a money decree. What you are asking for is a money decree. This money decree has many features. Merely summarily saying that somebody has said he has worked for 11 crores, so paying the money, that may be difficult. Money decree has to be sustained on specific finding with reasons that what would be the impact if the entire work is not completed, how much work was left to be executed. These are factors which will come in, whether one likes it or not. So would you both like to examine this aspect of the matter? and address the court. You need a statutory basis. And you may wriggle out of the matter on the ground of privity of contract, but had he not been a MSME enterprise, that argument was attractive. But he is automatically protected under a statute of the parliament, which we cannot, we cannot say that, sorry, no contract, you forget it. That can't be the case. Because ultimately, your section 70 will, some facet of section 70 of the Contract Act will have a bearing. Will have a bearing. That the only question is, do we embark on this exercise and determine how much he is entitled? These are disputed questions of fact. We can't. None a single judge didn't, none a single judge couldn't have, nor can we. So he cannot be left remediless. That's the point.
But the remedies, Lordship has rightly pointed out this under the 2006 Act. He can approach the council,
No, is the council functional?
that of course, I'm not.
Is there any decision on how the council is supposed to act? These are matters which will require some deliberation. We cannot rush into it.
Let's say,
And one aspect, further may I be permitted to say, the tender conditions did not require the principal contractor or the subcontractor should be this MSME category subcontractor. That was not our requirement under the tender. He was appointed by the principal contractor. We have seen in credential, whatever required in the, as per the clause, we have to see public interest and national security point, etc. And we have approved it. So
That is why we are saying it is done with your approval. You cannot say that we are not aware what is happening. We don't recognize him. You can't say that. Now, he has certain rights protected under the statute.
He have legally executed the work. That is one of the elements, section 70, he has satisfied. We have also received the amount, the work. So he is entitled to the amount, but from whom? That is the question.
From whom means from you, obviously.
We don't pay him because that's what the question of this privity of contract. Also, we paid for the principal.
That is why we are saying the statute
Yes.
protects him. You can't
Yes,
take
but-
this plea. Moment 2006 Act comes, you can't take this plea. Whether there is a contract or not, his right is protected by the statute. You are moving from a realm of contract to a realm of statutory right. That is beneficial for him, and that there he has a strong footing. You're right, there is no privity of contract. But what if his right is protected by a statute? There is no need for a contract then.
Right.
Compensations, damages, and any kind of pecuniary grant can be paid under three heads. One, statute. Two, contract. And three, tort. Number 2 and 3 are not applicable here. But that doesn't mean number 1 is not. The only thing is that this matter was not approached from that angle. Would you like to do it? That's the question. Otherwise, we can either allow or dismiss the petition, appeal. That is an option. But that is not going to bring any solution.
That's some time may be granted to us. Some time may be granted to us. Will
time for what?
For having the instruction and also.
Instruction, what is that? These are legal issues. Your client cannot give you instruction on law.
No, that is there. That is there.
let's say, may I be permitted to place whatever my learned friend has submitted are beyond the records.
Then we'll hear and cut from this. Yes, complete your arguments. Sir.
Yes. Lordship, may be pleased to come to
Just a minute, just
for page. Lordship, may be pleased to come to the contract agreement.
Just a This is a question from because non-beneficial and benefits of the other
Yes, to start.
The council submitting that council is functioning.
Council is functioning. Industrial Felicitation Council is functioning. So the submission of my learned friend, that there is no privity of contract between the appellant and the respondent lordship. That submission is absolutely incorrect and beyond the record. Your lordship, please to come to the no. Regarding the definition of the subcontract lordship, which is a page 48 definition, your lordship, other provisions under the heading part 6 subcontract. So here lordship,
Page number?
Page number lordship 95. Page 95. Oh, sorry, Lord. It will be, Your Honor, Lordship. Contract page is there. Lordship may come to memo appeal pages.
Mr. Saike, work has been executed to another contractor now. Is it the same work?
Yes.
Balance part
Yes, sir.
at risk and cost,
My lord.
at the risk and cost of the original contractor.
Perhaps not, my lord. I have to, my lord, clarify on that point, my lord, because fresh NITs have been issued, my lord. Not only once, I think twice or thrice this has been, my lord.
No, but we are asking, is it a risk and cost contract?
That I have to verify, my lord.
If it is a risk and cost contract, then without an adjudication, you cannot recover.
Yes.
That's the law.
No, Lordship, there is nothing in the subcontract, Lordship, there is nothing, such type of things have been mentioned. Here, Lordship, the subcontract has been defined that if it is approved by the principal Lordship,
Where is that? Which is that provision, sir? Which is that provision?
yes, Liani subcontract,
Yes.
yes, sir.
167.
Page 167 of the memo.
167.
Yes, Lordship. 167, subcontract defined.
Contractor.
Subcontractor means a person or persons to whom a part of the work or the maintenance has been subcontracted by the contractor and the permitted legally successor entitled to such person but not an assignee of such person also. That is the definition. So our the subcontract of the writ petitioner that was approved by the NHIDCL, that is the appellant. That subcontract also approval, Lordship, I have annexed. In the writ petition also here and also then Lordship may please to come to Lordship may come to page 175 of the memo appeal. 17.
175.
Yes.
This is the letter given by the appellant Lordship to the main contractor, Your Lordship. Para, based on your proposal, para 2 Lordship, based on your proposal for giving subcontract to MS Green Deca for additional length of 2.33 kilometer, the proposal has been approved in principle by upper headquarter NHIDS subject to following the conditions. So this was, there is no doubt that this subcontract was approved by
What are
the
those conditions?
Lordship.
What are those
Conditions, okay,
conditions?
as per the subcontract, Mr. Green Deca is eligible for execution of the additional work for rupees so and so, so which would be equivalent to cost of this additional length of the project based on average cost per the kilometer. The contractor has intimated the change of the subcontract by the letter dated so and so for a length of 2.33 kilometer. The subcontract will be governed by the contract agreement signed between MORTH and the contractor. This is also very vital, Your Honor, because the subcontractor will be governed by the whatever the terms and conditions applicable between the Lordship, the principal appellant and the main contractor Lordship, that will be applicable to the subcontractor also Lordship. So submission made by learned friend that there is no privity of contract is absolutely untenable and not maintainable Lordship. And tripartite agreement between MORTH contractor, Corson Construction and NHIDCL. The responsibility to complete the project as per schedule J and all other solely lies with the contractor MS Corson Construction Company. The subcontractor of a part of the project length in the subcon Green Deca shall not Green Decker shall not absolve the contractor or its responsibility to execute and complete the project and as per the contract agreement signed on it now, tripartite agreement signed on 5/5/30. The act of the subcontractor shall not shall absolve the contractor of missing the first milestone mentioned in the schedule J of the contract agreement penalty for missing the contractor shall be responsible achieving all milestones in the schedule G. Then Lordship, page 176, clause number Roman 5, in case of failure of the subcontractor either to execute the work within the time or of required quality, all the actions as mentioned in the contract agreement shall be initiated against the contractor. Then Lordship may come to the other definitions in the contract agreement.
11, no payment. Clause 11 also.
Lordship may come to page Lordship 155, 155.
Yes, what?
155.
Yes,
Lordship, sorry, Lordship, next page, 156.
156.
156, 156, next page.
Yes.
Lordship, definition, third party is defined, Lordship, under clause number 27.11 at the bottom. At the bottom. The agreement is intended only for the benefit of the parties and their respective successors and permitted assigns, and nothing in this agreement shall be construed to create any duty to standard of the care with a reference to or any other agreement shall be binding and in to the benefit of the parties and their respective successor and permitted assigns. Lordship, here the doctrine of
27.11 पढ़ रहे हैं आप?
yes, third party, definition of third party.
Third parties, this agreement is intended solely for the benefit of the parties and their respective successor permitted assigns.
Yes.
And nothing in this agreement shall be construed to create any duty to standard of care with reference to or any liability to any person not a party to this agreement.
Yes.
Yes.
Not a party, that is correct. So I am a party because Lordship, once the work was assigned to me for a smaller area, Lordship, 2.33 kilometer, Lordship, I become the assignee. When I become the assignee, Lordship, I will deem to be a party to the contract. Then Lordship, will please to peruse the this definition of successor and assigns. Just below same page 156, 27.12. Clause. Successors and assigns. This agreement shall be binding upon annual to the benefit of the parties and their respective successors and permitted assigns. So my subcontract was approved. So I was one of the assignee. Additional affidavit and additional affidavit. Yes. Page 460.
Yes.
Yes. Then your lordship may be pleased to come to this page 462, because my learned friend, your lordships also had submitted that why we did not approach the go for arbitration. We had filed application, lordship, for adjudicating the dispute through the arbitration proceeding, but no reply was given. That will get your lordship at page 462, where the principal contractor had demanded arbitration.
You demanded arbitration.
Main contractor.
Main contract.
Main contractor has
Yes,
demanded.
yes, yes. So I am his assignee.
Yes.
Then let your lordship may please to come to page 465. A high level meeting was held in Delhi, lordship, 465 page.
Yes.
At Delhi, lordship, and in that meeting, the subcontractor, his Green Deca, his name has been shown at serial number N, lordship. He was also invited and he participated. In that meeting, lordship, they may come to
What has happened to the other subcontractors?
they were paid.
They were paid
Without any, their contract was not approved by the NHIDCL lordship. But that document is also on record, but they were paid without any approval from the National Highway.
Is that correct?
Yeah, I have given the annexures, lordship.
My lord, that is utility services.
Whatever it might be, lordship. They had all the contract, not only that head office.
Utility services means?
My lord, this is in fact prior to the starting of the, my lord, actual execution, the telephone lines or, my lord, the electricity lines or some pipes of the water, etc. These has to be removed from the site with the, my lord, permission and the association with the concerned authorities. So for that,
What is there was no contract between the subcontract between the contractor and those utility the persons who have
That was
provided the utility
included.
services. There was no subcontract between the principal contractor and the persons who have provided those utility services.
my lord, that was they have the, my lord, this principal contractor has the contract with those persons. They they submit the bill to the Persian Cobham, the principal contractor, then my lord, we reimburse it. My lord, the payment is being done by the principal contractor. We reimburse the bill, my lord. It is not part of the, my lord, contract, my lord.
It was a part of contract.
Was there any other subcontractor in the same footing as the writ petitioner here?
He had one.
Nobody else.
Only one.
And others were all doing ancillary utility services.
Those 1 crore and odd amount after 11 crores, my total was found something 12 crore and odd, 11 crore his work and 1 point some crores for the utilities.
You argue, Mr. Roy, as much as you want, but finally tell us which is the correct forum to adjudicate this dispute. Writ of mandamus.
My humble submission, Lordship, as per the division bench judgment, your Lordship is aware of our own High Court, where the amount is admitted, the writ will be maintainable. Writ will be maintainable, Lordship. That is my one point. My other point is, Lordship, as submitted my learned friend that there is no privity of contract, then my case will be covered under section 70 of the Contract Act. I have given the series of apex court judgments, Lordship, where the apex court held that even there is no need of any contract agreement for execution of the work. If the work has been done and the benefit is deriving by the authority, Lordship, they are bound to pay. Your Lordship will recollect that Mandal case, your Lordship had delivered the judgment. That judgment also I have supplied. So, Lordship, here, Lordship, the entire, when the argument of my learned friend, there is a arbitration clause, but see the contradictory points are good. One side, the NHIDCL submitting that there is no privity of contract. Other side, Lordship, they are saying that I am the come under the definition of third party or subcontractor or Lordship survivor. This contract agreement itself provides that even if the contract is terminated with the principal contractor, the terms and conditions of the contract will be applicable both for the main contractor and the subcontractor. That is the survival clause in the contract agreement, Lordship. So my humble submission is this, Lordship, what your Lordship has suggested. I think it will be better to take some other day in the meantime.
Why? Why other time, other day?
Lordship earlier suggested no for this going to MSME all that.
That.
Or I may continue.
You want to look into that aspect, it's another thing. Otherwise, whatever we.
And how the amount, Lordship, how the amount is admitted, your Lordship, please to say it.
Mr. Roy, all the judgments you have referred to, those were not cases where the contract was terminated. Section 70 has its own application. We are aware of it.
Yeah.
But this is a case where the work was not completed.
No, I had completed my.
You had completed your work. Your assignment is from the principal contractor. You are now seeking the payment from the main employer with whom there is no privity of contract. That's what they say.
Once the subcontract is approved by the principal, Lordship, then Lordship, I have given the judgment, Lordship, and Lordship, maybe please to consider
Please consider this clause number, page number 61. Come to page number 61.
61.
Obligations relating to subcontracts and any other agreements. 3.2.
Yes. Contractor shall not subcontract any work in more than 70% of the total length of the project highway and shall carry out works directly under its own supervision and through its own personnel at least 30% of the total length of the project highway, provided over that in respect of the works carried out directly by the contractor, it may enter into contract for the supply and installation of the material, plant equipment, road furniture, safety devices, labor, as the case may be. For such works, for the avoidance of the doubt, the parties agree that the contractor may subdivide the affords a length of 30%
Three
in
point-
no more than 5.
Next page, 3.2.4.
3. They actually agreed that the contractor shall at all times be responsible and liable for all the obligation under this agreement, notwithstanding anything contained in agreement with its subcontractor or any other agreement that may be entered into by the contractor, and no default under any such agreement shall excuse the contractor from this obligation to liability or liability hereunder. Here, Lordship, there is,
So
I have
suppose-
completed my
suppose
work.
Suppose tomorrow, they have approved the subcontract and the contractor fails to complete that work. Whether the NHIDCL can directly claim the whatever the damages from the subcontractor.
That will be applicable, this clause will be, my humbly submit, Lordship, this clause will be applicable if the subcontractor fails to complete the work assigned to him. Here my case is that, Lordship, whatever work was assigned to me, I had completed, which is admitted fact, Lordship, which is admitted fact.
That also they are disputing. You were assigned to do the work of 26 crore and you have completed 11 crores work.
No, Lordship, no.
That is their stand.
No, that is not correct, Lordship.
That is their stand, sir.
No, Lordship. They had offered me 2.33 kilometer, which I come. Here their own documents show that I had completed the work in all respects. I had taken more than 5 crores from the bank, Lordship. My living house, residential house,
Mr. Roy, finally, this is the last time we are asking. You are not trying to appreciate what we are saying.
yes,
This argument can only come to your assistance if you have a statutory protection as a MSME enterprise, not if you are a part of a larger contract agreement, because all the judgments you have cited, none of them are on a terminated contract. Whether it is quasi-contract, admitted amount, none of these judgments are delivered in a fact situation where the contract is terminated. This is a case where the NHIDCL has terminated the contract with the principal contractor.
yes.
You may have done your part to the principal contractor, but they are saying our work has remained incomplete. So there is a dispute. We are entitled to recover money from the principal
They had
contractor.
recovered, Lordship, after fixing the damages, Lordship. After deduction, Lordship, even I am entitled to get, Lordship may come to page
Who
3.
will adjudicate these things? Where is the adjudication of these facts? Has the learned single judge adjudicated these facts?
Yes, yes.
Where is it?
See the documents before that, Lordship. See the 378, page 378. It is admitted fact. My learned friend has submitted that damages has not been unpaid amount to the main contractor, that has not been calculated. That is not correct.
Yes.
Yes, Lordship, will please to come to page 378. Before that, I'd like to submit with your Lordship, main contractor was awarded 2 contracts. One was from Jorhat to Jhansi, and the second contract was from Jhansi to Dimo Sariali, Lordship. While calculating the damages, I am a subcontract only from Jorhat to Jhansi, not from Jhansi to Dimo. But while calculating the liquidated damages, Lordship, the NHIC had calculated both the amount, Lordship, for which I cannot be, Lordship, held responsible for the subcontract, which was, I was never the subcontract, Lordship. And that your Lordship will find, come to page 378. This is the letter of the authorized engineer of the NHIDCL, Lordship, dated 21st/8/17, Lordship, to the address to General Manager Project NHIDCL, Lordship, while terminating. And Lordship may come to Lordship may come to in the middle portion. Later on, the authorized signatory of Messrs. Carlson Carvey Construction SA has accepted and signed the measurement of the work executed, completed, uncompleted, including valuation of the work of the project, Jorhat to Jhansi section NS 37, and confirmed the same by the email at July 17, as determined by the authority engineer as per provisions clause 3.5 of the contract agreement. After termination of the contract, MS Corson Construction has neither confirmed nor comply as requested above under rule number so and so under the provisions of the 23.4 of the contract agreement. Authority engineer comment on these issues. MS Corson Construction had no plants and machinery as their own at the site. The work was executed by their subcontractor. So no any plants and machinery has been handed over to the authority. Then Lordship may come to page
Point H.
Lordship. Corson Caribbean Construction SA personnel left the site in first week of May 17, and site office was also closed in May 2017. After that, no personnel from Corson Caribbean site has seen at the site. Authority engineer presumes that the site has been vacated by Messrs. Corson Caribbean SA. Then Lordship may see the damages, Lordship. After the forfeiting of the encashment, bank, and everything, Lordship, page 381, whereas my learned friend has submitted that the unpaid amount or damages was not calculated by the NHIDCL. Ultimately, after deduction of the Lordship encashment, damages towards non-achievement of the milestone, encashments of BG against performance security advance, thereafter at the bottom, this net value of the payable amount after adjustment of the comes to rupees so and so. So this amount, Lordship, the main contractor is entitled to get. And the work which was, your Lordship may please to come to the next page, page 382. This is the letter of
So that's all, Mr. Rao?
no, page 382.
Yeah.
Next page. This is also the letter given by NHIDCL to the new contractor whom the remaining work was assigned. In consequence of the termination of the contract Jorhat to Jhansi section NS 37 due to gross default on the part of the previous EPC contractor, MS Corson Caribbean Construction SA, authority in India determined the value of the unpaid work completed, undergone as per the provisions of the contract clause 23.5. The gross value of the unpaid work determined by the authority engineer is 12 crores 26 lakhs 35,035. Only. Girin Deka, that is Lordship, the writ petitioner. Deka, and several, and the other subcontractor is rupees 1 crore 90 lakhs 49,056. Then work executed by Girin Deka is 11 crores 6 lakhs 85,770. So there is no dispute, Lordship. Then the admitted amount, Lordship, I am coming to the other admitted amounts. There are so many annexures, Lordship, showing that that amount is not disputed at all. Even the head office of the NHIDCL, Lordship, even the Lordship head office of the NHIDCL, they have directed the project director and others to pay to the subcontractor, that is the present writ petitioner. Lordship.
What is that?
Yes, that your Lordship will find.
But Mr. Sekar, if you are not paying, it may happen that you may end up 50, 60 crores, including of interest, because his right is definitely protected under the MSME Act. And that amount, whoever is liable has to foot the bill. Forget whether there is privity of contract, no privity of contract. Moment you take any work or supply from a MSME contractor, this person who accepts the supply of work has to pay him. Whether the contract is terminated, not terminated, privity of contract, no privity of,
That is,
nothing
yes,
matters.
yes.
So there you may have a huge liability. Be very clear about it. If you still want to finish it off with this amount, that's up to you. We are not definitely going to non-sit him.
No,
It's only a question of
he
whether
must have a forum
this,
to.
this forum or this procedure is correct. That's the only question. Because moment he goes under the Act of 2006, his
But that
rights are
again, my lord,
completely
what my
protected under the statutory statute. There is not required whether the contract is terminated or not. But the
Yes.
problem is under writ,
Yes.
he doesn't have any answer to that. He cannot have. The only problem is the contract out of which he is claiming payment, that contract has been terminated. The learned single judge did not and cannot deal with it. You can't give benefit of payment under a contract which is terminated. That is agreeable. But moment he goes under the Act of 2006, that objection is out. There you will not only have to pay him, but also with interest. We are trying to help him. He is not understanding. He is not understanding.
No, no,
This
Lord.
11
I
crore
agree
will
to that.
become 40 to 50 crores. Be very sure about it.
In one same nature of case, Lordship, the principal amount was only 65 lakhs. Ultimately, government has to pay more than 200 crores. I
You
had
are already
conducted.
sitting on a liability of 60 to 70 crores. You will have to pay him because you have admitted that he is worked. None of your arguments will hold good if the matter goes under 2006 statute. Be very clear about it.
Where is the direction by the chairman and NHIDCL?
Yes, Lordship.
That point, my lord, I will have to obtain instruction whether the.
First of all, yes, chairman
Yes.
NHIDCL.
पैसा तो देना पड़ेगा.
Is there any letter?
Lordship.
Is there any order or
Yes,
communication?
yes,
or
Lordship.
Where is that?
It is a valuable document, Lordship. Noted down that document is there.
What you people were doing? You are not aware of these documents. Where is that?
Council काम कर रहे हैं।
Yes. The gross default. Yes, Lordship.
Yes.
Page Lordship. 496. And it is a company, NIGDCL is a company, limited company, Lordship.
Yes.
It's not the page 4.
496.
Yes, Lord.
This is the addition, counter affidavit.
Lordship, I'll come. It is not right to mount the definition. I'm not the election.
This is the counter affidavit. On behalf of this respondent number 3 and 4 NHIDCL General Manager. They have admitted.
Yes, release the renewal. 496 to 40. अरे सुनो रहो ना भाई.
Yes.
Just a minute. Hey, bhai, Linux किया है. No, I'm not getting. Additional affidavit separate here. I'm sorry, Lordship. It is there, but I am not finding it.
It is not there.
It is here, Lordship, 100%.
There it is.
There is no doubt. But I failed to pinpoint the annexure. It is there.
So important document, and if it is not.
No, it is there, Lordship, 100% I am sure.
Where is
It
that?
is there.
Point it out tomorrow.
Okay.
Point it out.
Achha, is there any admission about the dues in the affidavit?
Yes, yes.
Where is admission is there?
Yes.
Which
in
page? Which
Philippine-
page?
Lordship,
Affidavit,
yes,
not letter.
yes. Affidavit in opposite reply, Lordship, filed by the NHIPCL.
Yes, which
Page 403. Actually, the volume should have been split up in two volumes as per the High Court.
What is that exact paragraph? Yes, para 4. Minimum 60 to
Yes,
70
yes.
crores.
Admitted,
Mr.
Lordship, affidavit, no, sorry, Lordship,
It's
399, 39.
Yes, yes. Para 4.
This is the same paragraph quoted in the judgment.
Such a file by, okay. Where is the NHIDCL affidavit admission?
Yes.
Admission on the part of the NHIDCL. That much of amount is paid. This is your affidavit, sir.
Recommended question.
No, it is there. I have seen it. Coming here.
401. Style.
401.
Affidavit in reply, sorry.
It has been accounted for in the termination of payment deficiency. Unless he goes on the behalf, he has no, absolutely no way.
Sorry, Lordship, 382, page 382.
382.
382. This is the letter here by the NHIDCL. Yes. 382.
Is the project management, FP project management. This is letter by FP project management.
Yes, Lordship.
So where is the question? You said that the NHIDCL director.
Yeah, he's the team leader, Lordship. Ramnath Singh, team leader come senior highway engineer, Lordship. He has mentioned the amount that the work executed by the writ petitionary 11 crore 6,35,770, Lordship. Apart from that, Lordship, in not only that, Lordship, for that amount, Lordship, NHIDCL deducted TDS.
This is what the letter which you are referring to.
No,
The NHADCL chairman, this is what the letter, this 382.
No, that is another letter. I'll place tomorrow. It is there on the,
Is there any letter?
I am not getting the exact page number, Lordship. I am sorry. I am extremely sorry for.
Tomorrow.
Tomorrow.
Only for this,
Okay.
refer the letter and then.
Yes.
for it.
It is there very much. I have prepared a synopsis, but
Tomorrow.
I am not getting that synopsis in my brief.
Tomorrow. ये रख लेना सारे. Only for this one.